is facing financial constraints.
It's in the list.
Huh?
Running in the list.
Before it was
Now it is running in the list, monthly list of November. Next. Yes.
My lord, kindly have a look at the order. My lord, the division bench chaired by Honorable Justice Pal has been pleased to set aside the order of Justice Mantha single bench with the direction to send the matter. The matter has been sent to your lordship, and we have been asked to file a fresh application for stay and my lord, to have the matter on merit as early as possible. Kindly have a look at the order first.
So what do I do?
Kindly have a look at it, my lord. Kindly have a look at it. My lord, paragraph 30, 31, 31 and 34, 38. The matter went to my Honorable Chief Justice Court. Then it, with the change of determination, went to Court of Justice, Sujapal Division Bench, and my lord, the matter has been ordered. Well, let this appear as to mention, my lord.
My order.
No, my lord, order of Justice Mantha, and my lord, that has been set aside. That has been set aside, and my lord has been sent to your lordship. Has got the determination. Your lordship is pleased.
Hearing matter.
My lord, let this come as to be mentioned.
No, it is hearing on affidavit.
My affidavit has been extended. My motion.
When should I take up? You tell me.
My lord,
hearing matter.
Well, only thing is the clarity, my lord, there is applications we have been asked to. He is in the employ of DBC, my lord. At any moment, the Chief Justice, Honorable Chief, please to direct that his service shall not be disturbed. And my lord, you come up with an application for stay. So, my lord, let this appear as to be mentioned, my lord. Otherwise, my lord, they will show me that door, my lord. Marching order may be passed. Let this appear as to be mentioned, or my lord, motion stage.
How can it be in motion if affidavits are complete?
My lord, because my lord, we
take the microphone.
No, my lord, we have seen that even if the affidavits have been complete, everything is complete, and the amicus curiae has been then it has been kept in the motion stage because that will be finally disposed of.
Show me.
Well, not that there is any data. Well, we have got experience in other courts.
Experience.
My lord,
my experience is otherwise.
My lord, I am before your lordship. My lord, I am protected by your lordship. Kindly protect me, my lord. Well, I have to come up in that application for stay, my lord. Let this to be a to my lord. Your lordship is aware of all these things, my lord. How difficulties we face, my lord.
You said within 2 months?
No, not 2 months, my lord. Only application. My lord, I have been asked to, when we paid for stay of the operation, so far as services concerned.
Give notice to other side, then mention.
And my lord, kindly get to be mentioned, my lord, notice, kindly.
Notice to other side, then mention.
My lord, I beg to be excused, my lord. It will be easier for us, my lord, if it is.
It will not be easier for this court, sir.
Well,
it may be easier for you.
Deeply.
Lord, may I most humbly permitted to mention one matter from the original side of your lordship's determination.
Deeply obliged.
Thank you, sir. Aji kau tarik? Hey, দিদিমণিকে ডাকো। বেস থেকে আরেকটু এদিকে আমার দিকে সরিয়ে দিন। বেস থেকে। বাস, থ্যাংক ইউ। থ্যাংক ইউ দিদি। Yes, sir.
Original side matter, my lord, may I kindly be permitted, my lord. This is the matter where a judicial officer has been dismissed from service, my lord. Your lordship was hearing the matter last occasion on the ground of Mr. Joydeep Kaur, an adjournment was sought for, my lord. The matter was running in the list of 18th of August, but generally your lordships takes up the original side matters on Tuesday and Thursday in the second half. Yesterday the matter was not in the list, my lord. That is the reason I am mentioning the matter today.
After vacation, it will appear.
Lord, there is some urgency in
Monthly
this
list
matter.
of November.
Lord, your lordship
Court
was
application or hearing?
hearing matter, my lord.
Hearing?
Yes.
Hearing, heading এ কোথায়? আমার original side এর লোক কোথায়?
Lord, kindly takes up the last order, my lord. Your
Well,
lordship.
how can I do, sir? Original side people is not here. Original side is not there. Never nani lovely. You come on the original side day, then
Look.
mention.
Very well.
Yes.
My lord, may I be permitted to mention item number 251 of the from the monthly list of August, my lord? My lord, what happens in this matter, my lord, is pertaining to inaction on part of the authorities for not replying my RTI application. My lord, this is a group 9 residuary matter, my lord.
To be mentioned
I'm grateful.
tomorrow.
I'm grateful.
Give notice, sir. Other side to be mentioned tomorrow.
I'm grateful.
Yes.
Well, item number 1, and you lordship adjourned the matter yesterday.
Yes.
In this matter, I am for the state, my lord.
Yes.
For the
It is pertains to panchayat.
Panchayat. No, my lord. My lord, lordship, kindly.
Dekhi.
Postal department.
Postal department. I'm sorry.
They have a look into page 23. Kindly have a look into page 23 first. My lord, signature of the appointing authority. My lord, Deputy Director, Small Savings, South 24 Parganas, Alipur. This is not Postal Department. Finance. Next page, page 24, Linua. Finance Department, Government of West Bengal, Finance Department. Office of the Deputy Director, Small Savings, South 24 Parganas. Order.
So it will not go to CAT?
No.
Why?
My lord, CAT, my lord, central, my lord, appointing authority, finance department, government of West Bengal. CAT, central government employee.
Oh, finance. So it will not, I'm sorry, not go to the set?
My lord, not because this is the agent. Kindly have a look into page 24. Another thing, my lord. Agent, Dipendu Rai, my lord, as an
All right, let it appear as motion. The point of maintainability, you will take.
for maintenance, not maintainability, my lord.
Of course, I will hear them.
Termination. Termination. Maintainable, not determination.
So first determination, then maintainability.
My lord,
They yesterday took a point that it should go before the, take the microphone.
So he is not an employee under postal or central administration central. So it is under the jurisdiction of High Court, my lord, subject to correction, subject to lordship correction, my lord.
You are appearing for?
For Union of India Postal Department, my lord.
postal. My lord, great.
Because he is not an employee actually.
My friend, my
He
lord,
is an agent,
agent, my lord.
subject to lordship your card.
All right. What is the urgency?
My lord, urgency is that,
আচ্ছা লিখে দিন আসুন।
my lord, 1 minute, my lord.
Upon showing urgency, the writ petition shall appear as pleaded by Mr. Uday Shankar Chattopadhyay, learned advocate, appearing for the petitioner. The matter shall appear under the heading Motion Service on September 15, 2025. Paragraph, the point of maintainability is kept open.
কবে বললো?
15 সেপ্টেম্বর।
I'm good.
My lord, I am appearing for the.
Why release?
My lord, this is relating to my lord, panchayat service. The petitioner, other of the petitioner is a gram panchayat, was a gram
All right.
panchayat.
Lord, I am appearing for this.
This writ petition, MS Pompa de Dhobol, learned counsel, comma, in her usual fairness submits that this writ petition pertains to group
My lord, group 5.
Group 5 of the classification list. Paragraph. Mr. Pinaki Dhol, learned advocate, appears for the state. full stop, he also confirms such submission. Paragraph, the paragraph, due to want of determination, this writ petition is directed to go out of the list of this court and to appear
Correction করুন
before the
এটা
appropriate bench.
ওটা correction করে নেন
Full stop. Records are directed to be sent before the appropriate bench forthwith.
sir. Probably my lord the classification list should be corrected, otherwise my lord
Paragraph, leave is granted to the petitioner to correct the classification heading in the presentation form and wherever it is required.
my
In course of today.
শুনুন না দিদি, ওই আমি পাঠিয়েছি ওই কালকে দুটো বাচ্চা না, ওগুলো না, ছোট ছোট অফিসাররা নিল না, অরিজিনাল সাইডে নিয়েছে বাচ্চাটা, আমার জাজমেন্ট ফর্মে করতে পারে, তো আমি সেগুলো লিখে কারেকশন করে দিয়েছি, দিয়ে বলেছি আপনার সঙ্গে বা অথরিটির সঙ্গে কথা বলে নেবেন না, এটা দেখিয়ে দেবো। Yes. Number? None appears for the parties nor any account.
I am for the statement.
Petitioner, petition.
My lord, I intend to become a party respondent in this writ application, my lord. It is so because your lordships may
You have
kindly,
taken out the application.
my lord, we have just come to know from your lordship's last order that the OA number 303 is also pending adjudication before the learned tribunal. Now, my lord, we are party respondents in the OA 303 of 2024, which is before.
Fees for the union.
Dheeraj Trivedi was appearing. So Dheeraj Trivedi was appearing.
Where is he?
Of the last occasion is a direction upon the respondent to serve copy to the respective party. On behalf of EPSC, I am served your lordship's orders. Let it be kept in the record.
Done. Yes. This part, kindly take the order. Take the order.
My lord, the
Lordship,
Yes, ma'am. The direction, state will communicate and get the respective party and Union of India as well as the EPSC will communicate. Deliberate portion of it.
You have served upon respondent number 1 and 2.
I am for only one, if one public service.
No, no, what was the direction upon you?
Half copy of the respective department.
So you have done that.
Yeah, I have done that, that is the document.
All right, wait.
Yes.
In view of the above, the appropriate authority of the state
yes, my lord, the
shall forthwith communicate the relevant facts and materials along with a copy of today's order, comma, a copy
that,
of the
that's
previous
what I
order
was.
passed in this writ petition and a copy of the order dated such and such to the respondent number 1 and 2 with reference to the said communications at pages atho and atho to the writ petition. You have done that.
Lordship, this is awaited. It is in the process. But many things. Process means Lordship, the directions was comment the relevant facts and materials along with the copy of the order.
Kindly take the order.
No, I'm reading the order.
Yes, in view of the above.
The appropriate authority of the state shall forthwith communicate the relevant facts and materials. These relevant facts and
Kindly
materials,
read on.
along with a copy of today's order, a copy of the previous order, such as referred to in the order dated 23rd July to the respondent number 1 and 2 with reference to the said two communications at pages 158 and 159 to the writ petition as referred to above by the learned additional government pleader. Now, my lord, this so far as comment of the order, there is no problem. Only thing, my
Why
lord,
haven't you do that, sir? Why haven't your officer done that?
no, my lord, Lordship kindly sees, my lord. They are collecting all relevant facts and materials.
When the order was passed?
No, it has no, your Lordship directed.
30th July. Today we are on,
Lordship gives.
ask him to be present here and explain. Tomorrow.
Lordship.
No, who is the officer? Come on, tell me.
Well, it is the appropriate authority of the state.
Don't respond now. Yes, tell me who shall come and explain tomorrow.
Lordship, Lordship, kindly bear me for a minute.
No question of bearing.
Lordship, kindly see, but this has to be in compliance with the directions of your Lordship. But the compliance of your Lordship, communicate the relevant facts and materials. These are being collected, and there has been substantial progress. It will be done immediately. Possibly within 7 days, it can be done.
No, by tomorrow.
Lordship,
Or else I will direct on day after tomorrow, the concerned officer must come and explain
it is
why it has not been
Lordship.
done since 30th July,
Lordship.
2025.
I have certain other things to advance before Lordship. Your Lordship order will be definitely complied with.
Discompliance, first
No.
discompliance.
Yes, that will be done.
No question. Tomorrow it will be done and come back.
Lordship gives at least some time.
No, sometime.
Because
30th July.
yesterday
Sorry.
the officer came to us
Anyway,
and
let
said
me,
that
I will pass my order. Don't worry. Yes, next.
now, one
Next
more thing
paragraph.
I'll have to submit.
Done at Deputy Solicitor General, Mr. Such and such also shall also communicate and serve a copy of today's order along with a copy of previous order dated such and such, passed in the writ petition, and a copy of the order such. These are all communicated.
I communicated on behalf of UPSC to the UPSC. Only for UPSC.
It is for the Union of India to do that.
Union of India will do. Actually,
You are appearing for?
UPSC. Union
Who is for Union of India?
Mr. Dwivedi.
Dheeraj Trivedi is appearing.
You just inform him. I'm keeping it. I'm passing it over.
Now, one thing, I'll just to assist your Lordship, it is not a default, that way.
Of course, default.
No, Lordship, kindly, pardon me to express myself. Now, the officer came to us that he's the voluminous records are being consulted. It takes time. Your Lordship's order has.
Very well. I will record your submission and I will say no further steps shall be taken in the matter.
Lordship, kindly.
I will say.
I'll show only one document to your Lordship right now.
No.
They have no cause of action at all. They don't come with.
I want this communication. Then whatever document. I want this communication to be made. Failing which, no further step on the matter.
Further step in the matter means
Nothing. No further step.
they are not eligible. They do not come within the zone of consideration.
Who?
They petitioners.
That I will hear on merit. First, you communicate this order. First, you comply with the direction of this court. I will hear on merit. I will hear on merit. In view of the order passed
The
by
petitioners
Justice
have
Sinha.
no case, even before Lordship.
Mr. Additional Government Leader, it is your, state submission before Justice Sinha. That nothing has been done.
It is unconnected matter. That is an unconnected matter. I'll immediately. They are 1998 batch.
Very well.
The
I will
promotion is.
hear out on affidavit, but first you communicate and come back tomorrow.
Lordship gives a little more.
No,
little more time, because.
First you have to communicate. Then I will hear.
I have one respectful submission.
Sir, you have made an application.
But I will be coming up with an.
So you come up, then I will see. You will come.
Lordship gives for at least a week's time.
Where is your locus? Now tell me.
I have come with the.
Why should I hear you tell me?
Only because.
No, why? Where is your right of audience?
Because of the.
Where is your right of audience?
Because of the.
First, you satisfy me that today you have a right of audience without any application.
It is, that I bow down to your Lordship.
So first you satisfy me.
I appreciate only one thing, my Lord. Your Lordship.
I will not take cognizance of your submission, sir. You come up with an application, I will hear you. Nothing doing. Yes, Mr. Dwivedi, you have communicated.
Milord, I suppose Milord will give me 1 day's breather, Milord. Milord, we have communicated now.
The order was on 30th July.
Milord,
and on 20th August, I am hearing 1 day.
Milord will.
And the state is saying they have not yet communicated. They will take more time to communicate.
7 days time, I am asking for, praying for.
Yes, Mr. Dwivedi.
Milord, I cannot say that I'll require 7 days time to communicate because I cannot cut that sorry figure, Milord. Because Milord, I was not there, Milord, and I was lying indisposed, Milord. So therefore, Milord will give me one.
It is for you. office to do, Mr. Trivedi.
I apologize.
Come tomorrow. At order করে দিন।
My lord, my
My lord,
recorded, I have to.
My lord, only
Ashu.
one prayer, my lord.
Ashu.
OA 303,
আসুন।
my lord, which
It's
your
been
lordships have been referred to. We are
in the order.
there too. My lord, it is
Ashu.
already in the order. Lordships may kindly takes up your
Miss
lordship
MS,
30th July.
MS,
দেবান্বিতা প্রামাণিক
Devanita Pramanik, learned advocate, appears for the petitioner. Mr. Shopon Kumar Dotto, learned additional government pleader, appears for
the state respondents.
respondent number state. Your name?
Arun Gandhi Chattopadhyay for
Mr. Arun Kanti Chattopadhyay, learned counsel, appears for respondent number 1 and 2.
one, only one. One Union Public Service Commission.
On respondent number 1, stroke
Public Service.
Union Public Service Commission. Who is appearing for 2?
My lord, I'm
তুমি appear করো।
You are appearing for whom?
তুমি কারা appear করছো তা
Mr. Dhiraj Trivedi. Oh, sorry. 1 and 2 is Dhiraj Trivedi.
lordship.
Actually, there is a mistake in the respondent number 1. It will be separate. EPS is a separate entity. It's a constitutional body. From the very beginning, I draw.
All right. So who is appearing for? You are for
My
1.
lord, I am appearing for 1 and 2, my lord. Secretary Department.
এটা ইউনিয়ন পাবলিক সার্ভিস কমিশন করেছে কি করে করবে তুমি ইউনিয়ন
So you are appearing for 1 and 2 also. Oh, you are for 1.
One and
ঠিক আছে। Mr. Dhiraj Trivedi,
No,
learned
my lord, they have made a mistake. Union of India, I may appear. But as far as Union Public Service Commission, then
he is appear
then he'll appear because my lord, they have.
right. So you are appearing for 1.
no not one
He says you are appearing for 1.
union public service has not been made a party.
Union Public Service Commission has not been made a party. It has been denoted under the aegis of Union of India as respondent number 1.
Should have been through secretary or
separate party. Separate
Should have been a separate party, my lord.
separate respondent. From the very beginning, I draw your lordship attention.
আচ্ছা, very well. কি বললাম? Mr. Arun Kanti Chattopadhyay, learned counsel, appears for Union Public Service Commission. Full stop.
which is not a
Mr. Dhiraj Trivedi, learned Deputy Solicitor General, appears for
My lord,
Union of India
Union of India and respondent number 2.
and the respondent number 2. Full stop. At the outset, Mr. Arun Kanti Chattopadhyay, learned counsel, has submitted documents which are taken on record to show that he has communicated the orders as directed in the order dated July 30, 2025 to his client, Union Public Service Commission.
Seal and signature. They received it with seal and signature.
Full stop. Mr. Shopon Kumar Dotto, learned additional government pleader, submits to cause the necessary communication in terms of the order dated July 30, 2025.
the state is a pro forma respondent here.
To the respondent number 1 and 2, comma, his client requests at least 7 days time. First. The last order was passed on July 30, 2025, and today on August 20, 2025, such a prayer is made on behalf of the state. The materials which were directed to be communicated by the state authority are all on record. But still the state failed to communicate. Paragraph. In view of the above, the peremptory opportunity is granted for 2 days to the appropriate authority of the state to comply with the direction of this court dated July 30, 2025, insofar as the communication to be made to respondent number 1 and 2 as mentioned therein. Full stop. Learned additional government leader shall produce the proof of communication
But little more time be given.
on the next day. Full stop.
Many data collections.
Sir, 30th July.
No, your lordship is correct. But lordship, here many people
Very
are
well.
involved.
Very well. 30th
Takes
July.
time, my lord.
Very well. 3 days করে দিন। 2 days নাকি? আজকে কত তারিখ? আজকে কত তারিখ? 20 না না না। And full in view of the above. Granted till August 26, 2025. Paragraph. In the event the communication has not been made from the office of the learned Deputy Solicitor General by this time, such communication shall also be made
In the meantime.
within the aforesaid period. The writ petition shall appear under the heading, কি heading এ আছে? Motion topped on কবে বললাম? 26 বলেছি না? On August 27, 2025.
Grateful, my lord.
Full stop.
For this in
আচ্ছা, এইটার আগে একটা লিখুন, মিস্টার
বিশ্বরূপ নন্দী।
বিশ্বরূপ নন্দী, learned advocate, submits that his clients intend to intervene in the writ petition, but till now, no application has been filed. Full stop. As such, there is no right of audience of the client of Mr. Nandi as on date. Full stop.
I have only one more submission that we are
Next.
agreed party in the original.
I do not know. I do not know, sir.
lordship, I'm grateful, my lord.
You come up with an application.
My lord, I will.
Grateful for this indulgence.
Since
Well, I'm so grateful, my lord.
interim order lordship,
Huh?
since I'm looking for an interim order lordship, I'm praying for that.
It's there. Let's see. Let's see.
My lord, I'm grateful. Much obliged.
At item number 5, my lord, Mr. Doipan Sengupta is Mr. Doipan Sengupta is appearing in this matter, my lord. Today morning, he informed me that he's having some difficulty in his ears today. That's why he couldn't come to court, my lord. If your lordship may please.
Medical ground.
Yes, my lord. Fix any day next week, my lord. And
For
my
the
lord, one more
respondent,
prayer, my lord, since my learned friend has served the affidavit in report, my lord,
What form of
2
affidavit?
days after the stipulated time, my lord, leave may be granted so that I can affirm it and serve it by Friday upon the
Your exception.
exception, my lord.
My lord, my report may be taken on record in that.
Mr. Your name.
Samrat Depal, my lord.
Samrat
Samrat Depal.
Paul. Learned advocate appears for the petitioner. MS.
Afrin Begum, your lordship. AF,
Such and such appears for
IRCTC, respondents.
IRCTC. On the prayer of the learned counsel, MS Paul, trying to file exception in the form exception on affidavit. Exception na, ki report on affidavit
We have filed the report in form of an affidavit, your lordship.
stands extended till today. Full stop. The report filed in court today is taken on record. Full stop. Copy has been served on the petitioner. You have received.
Yes, we have received, my lord.
Paragraph.
Ready for
Petitioner shall be at liberty to file its exception in the form of affidavit on or before August 26, 2025.
18th was the time that was given to them.
file.
Full stop. The writ petition shall appear on August 28, 2025 under the heading কিসে আছে? Motion top.
That matter may retain its position, well. Matter may retain its position, well, that I'm praying. Well.
Full stop.
And you also record that the petitioner has joined
লিখুন।
in compliance with
Yes,
the lordship's
yes,
order.
yes.
He has joined.
Pursuant to the direction of this court, the petitioner has already joined at the transferred place
Bangalore.
at
Bangalore.
Bangalore.
Grateful.
Six, my lord, I am for the petition.
Six.
Six, my lord,
Where is your other side?
but I have served the respondent number.
Who are the respondents?
Respondents were the Union of India. Union of India, Railway, RPF matter. Railway Protection Force.
What is the urgency?
The urgency means that I have challenged the initiation of the disciplinary proceeding. But tomorrow is the date. That is why I mentioned this matter, my lord. But the disciplinary proceeding was
Show me
initiated
your affidavit of service.
on 13. One of the respondents served on 13th of this month. Yeah. Let me search. 6.
Where is the notice for today?
But it was 19th or so soon thereafter. 19th, 4, page number 4, my lord. 3 and 4 both. It will appear on 19th August or so soon thereafter. Yesterday, it is supposed to be listed.
You participate without prejudice.
But my
আসুন ওই ইউনিয়ন অফ ইন্ডিয়ার ফাইলটা দেখি।
without show cause notice, without giving any opportunity to make representation of the charge sheet, this has been proceeded. Your lordship, my lord, kindly have a look of the memorandum of charge sheet.
Madam, you appear for Union of India. Anamika Pandey.
I've informed the officer that this matter is not being represented.
That you do. I don't mind. Be there. And Mr. Shovik Nandi is also appear. Senior advocate. Ashun. Upon urgency being shown, the matter was mentioned yesterday by Mr.
Brotin Kumar De, my lord. Myself, my lord. Brotin Kumar De.
Brotin.
BRATIN, my lord.
Protein.
Brotin, N, my lord. N for Nagpur.
Protein.
N for Nagpur.
Protein.
Pratin. B for Bombay, my.
Oh, Protein. That's
Protein.
why I'm saying.
Yes, Protein Kumar De.
Kumar De. কি বললাম? Learned advocate appearing for the petitioner when the matter was directed to appear today at top of the list. Considering the fact that the disciplinary proceeding against the petitioner has been fixed on
Tomorrow on
tomorrow,
21st August.
Tomorrow, that is bold, August 21, 2025. The hearing of the disciplinary proceeding. The petitioner has challenged the legality and validity. Petitioner has challenged the legality and validity of the disciplinary proceeding on various counts. First paragraph. Learned counsel for the petitioner submits that the disciplinary proceeding is not sustainable in the eye of law, and the authority has been proceeding with gross malafide against the petitioner. Be that as it may, comma, the affidavit of service, affidavit of service filed in court today is taken on record. Affidavit of service filed in court today, niche, affidavit service niche, shows that notice has been served, notice was served upon Union of concerned authority of the Union of India, mentioning that the matter shall appear in the list on August 19, 2025 or so soon thereafter. But still, none appears for the Union of India today. Paragraph. In view of the above, considering the urgency in the matter, MS Amrita Pandey, Anamika Pandey, learned advocate present in court, and Mr. Shovik Nondi, learned senior advocate, who normally appear for Union of India, are requested to appear in the matter, comma, to hold the brief to assist this court henceforth. Their appearance shall be regularized by the appropriate authority forthwith. Paragraph. The petitioner shall serve copy of the writ petition upon MS Pandey, learned advocate for the Union of India, along with a copy of today's order. Paragraph. As paragraph. It appears to this court that a substantial challenge has been thrown to the alleged disciplinary proceeding, against the alleged disciplinary proceeding in this writ petition. Which are required to be adjudicated upon. After hearing the learned counsel for the Union of India. Paragraph. In the meantime, comma, the petitioner shall participate in the disciplinary proceeding without prejudice to his rights and contentions in this writ petition, and the respondent authority shall continue with the disciplinary proceeding in accordance with law, but no final decision shall be taken without leave of this court. But no final decision shall be taken and published without leave of this court. Full stop. The writ petition shall appear under the heading Motion Service. আরে পরে appear করবে, টপ তো হয়ে গেল কাজ। Motion Service in the monthly list of December 2025.
Deeply.
In this matter, my lord, I am for the petition. This is an application for restoration of the motion, my lord, dismissed for default. And I have stated the reason, my lord, for
Within time.
Within time, my lord.
I'm appearing for the state respondent.
Within time.
Thanks.
Ash. Can 1 of 2025, this is an application for restoration of a writ petition which was dismissed for default on March 3, 2025, bold. And the restoration application has been taken out on March 6, 2025. Full stop. Sufficient count being shown. The order of dismissal dated March 3, 2025 stands recalled. Paragraph. The writ petition stands restored to its original file with number. Paragraph. Accordingly, can 1 of 2025 stands allowed to bold without any order as to costs. Next.
Service terms.
Petitionটা কবে আসবে? কবে আসবে পড়িয়ে নিই।
The matter will appear in the.
Well, I am for the petition, my lord.
8 and 11 are similar matters.
8 and
11. They were connected matters. Your lordship had passed an order.
Regarding the claiming the interest.
I will take up after vacation.
Your lordship.
Lordship, there was a direction to give an affidavit which they have not done. 2 months have gone, Lordship.
You have not filed your affidavit,
Your
right?
lordship. It has not come up from the department. It had to. I had communicated
It's not as simple as that, madam.
from Delhi.
These are all
Lordship
retired
can
people.
dispose of the matter in terms of the notifications I had handed over. Your lordship, keep it in the first week of September. It can be disposed of.
After vacation.
Your lordship.
These are all retired people, old people, Lordship.
This is connected.
Yes.
8 and 11,
8 and
two
11.
petitioner, same
Cause of action.
Same cause of action.
8
same-
and
11.
11.
Mr. Tariq Kasimuddin, learned senior advocate, appears for the applicant
petitioner.
writ petitioner. MS Anamika Pandey, learned advocate, appears for Union of India, for the state.
Union.
State for the Union of India. Both the learned counsel unanimously submit that the issue involved in this application is identical with that with WPA 19472 of 2024. 19472 of 2024, which is appearing under the heading for orders against item number 11 of today's list. Today's cost list. Full stop. they jointly submit that these two matters can be taken up together for final consideration. Accordingly, this application, along with WPA 19472 of 2024, shall appear under the heading for orders on November 12th, 2025. Full stop. You say that it can be disposed of on the basis of?
The notifications, I'll hand
All
over
right.
one.
MS Pandey, Learned Counsel appearing for the Union of India submits that these matters can be disposed of on the basis of notification dated.
There are several notifications. Notification passed by the Department of Personnel and
The notifications passed from time to notifications issued from time to time
from DOPT.
By the Department of?
Personnel and Training, Government of
By
India.
the DOPT? By DOPT, comma, Union of India. Full stop. She shall submit the bunch of notifications before this court on the next day, upon copies being served on the learned advocate on record for the petitioner.
The earlier order, Lordship, with the direction of affidavit, then there has to be that dispensed with that.
Huh?
There was the direction on 2nd July.
Case number
That there has to be there are direction on.
There has to be
there was the direction of affidavit to be exchanged. Now that order has to.
No, not required. Let them come. I have said that they are agreeable.
I'm also agreeable. If they, but the copy has to give it.
I have mentioned that.
No, give it away.
Next. Hey, Vivi. Senior advocate হবে না তারিক কাসিমউদ্দিন লার্নার অ্যাডভোকেট সিনিয়র না Yes.
I am for the petitioner, applicant and contempt and respondent in the review petition. I am filing my opposition in respect of the review. Sir.
I was thinking if I can take these after vacation.
Cannot.
I tell you why. Otherwise, I cannot be able to touch the motions.
Subject to correction. If your lordship sees the order, nothing in the review.
I'll take up. How does it matter? I will not be able to reach motion.
Which was taken in the original proceedings on the basis of same plea, it is wasting of time. It is wasting of time.
I will not be able to reach motion.
Otherwise, my lord, my client, they are now being aged. The original, my lord, the landowner died during the proceedings of the Honorable Division Bench. Division Bench.
কাল থেকে না লিস্টে একটু অন্যরকম ছাপবো বুঝলেন এই ফরওয়ার্ডার্স অ্যাপ্লিকেশন এগুলো সব মোশনের পরে দিয়ে দেবেন
So I want to traveling to your lordship. In this matter, kindly take it.
I cannot, I will not be able to reach motion.
Lordship's predicament, but
all right.
If your lordship takes the review.
Where is your other side?
My lord, I am praying for not today, ma'am.
Testing the patience. What can be done? Your lordship mandated within 7 days review, opposition to be filed. Your lordship given 3 weeks time to them. Almost.
Who is there?
My lord, Mr. Sushovan Sengupta is there.
Today.
Yes. Proceed.
My lord, just a minute. Key.
আমরা ফাইল করব আজকে লোকে শেরিফ রাইটার
My lord.
Subject to payment of cost.
Obliged, your lordship.
My lord.
Obliged.
Only for this day, my lord, because my lord, I am beseeching to my lord.
No.
My lord, I am beseeching to my lord. My lord, I am
25.
Yes,
the order passed.
Affidavit has already been prepared. My lord, only, my lord, I am, that's why my lord, I have come.
Come tomorrow.
Yes, tomorrow. Yes, I am ready. Today will
Passed over.
I am sorry, my lord. I should not do that, my lord. That's why, my lord, my lord, I'm saying again, my lord, I am tendering my unconditional apology.
ঠিক আছে,
Because it is my duty, my lord.
all right. Next,
It will remain its own position, I believe so.
let's see, I don't know.
Fine.
Motion has to be given preference. Because 15 days I will not be there in the September. I will go for circuit.
If
So these 7 days and the 10 days in September, these are the days I have in my hands
I
for
know,
taking up motion. So,
if some
No.
preference to be given this,
all right, next.
I leave it to Lordship, my lord.
Mr. Nondi, in one matter, I have requested to, that I don't know. I'm growing old, I cannot remember those. But I have requested you to appear with MS Pandey. In one matter. কি চলছে ডাকো? হ্যাঁ? বারো তো for orders. Yes, pass, কেউ নেই তো? ছেড়ে দিন, আসুন. None appears for the parties nor any accommodation has been sought for.
Lordship, this matter, Mr. Biani appears for state. Lordship is coming, Lordship.
None appears for the petitioner nor any accommodation has been sought for. The matter, paragraph, Mr. Naunchad Biani, learned senior advocate, appears for
State, Lordship.
state. The matter shall appear under the heading for orders on November 18, 2025. Next. None appears for the petitioner nor any accommodation has been sought for.
Petition is here.
13. Do it after vacation. Yes. কি বললাম? MS Nivedita Chakraborty, learned advocate, appears for the petitioner. Paragraph, Mr. Shovik Nondi, learned counsel, senior advocate, appears, learned senior advocate, appears for Union of India.
1 to 3. Respondent number 1.
Respondent numbers 1, 2, 2, 3. The matter shall appear under the heading for orders on November 18, 2025. Next.
I am for the respondent number 5, my lord. There was a directions to file affidavit in opposition. A week's time is required to file. It has been drafted. It has not yet been.
You are appearing for whom?
Private respondent, respondent number 5.
Private respondent? What about the state? Affidavit?
The report form of affidavit has been filed. I have filed the exception.
A report in the form of affidavit was filed by the state.
No, whatever. Come after vacation. Mr. Ashish Kumar Chaudhary, learned advocate, appears for the petitioner. Stated কে ছিল পালিয়ে গেল? Who is for the state?
Sorry, my lord.
You are for the state
Lordship.
in this matter.
Item 14.
Somebody else said I am for the state.
No, we filed affidavit, report on affidavit.
I don't mind, but who said just now I am for the state?
Okay, এটা ছিল।
Oh,
MD Galib, Mohammed Galib, learned state.
with learned.
Senior government advocate, appears for the state.
Sure.
Mr. Owen Bodal, learned counsel, appears for private respondent number 5. Paragraph. On the prayer of Mr. Bodal.
With Mr. Minor. Amanul Islam, my lord.
Yes, Mr. Owen Bodal, give your name, with Ramanuj Islam, learned advocate, for private respondent number 5.
5.
তারপর লিখুন, on the prayer of Mr. Bodal, time to file report on affidavit stands parentarily extended till.
Report, exception to the report.
You have filed your report.
Report has been filed by the
State.
I would file an exception. I have filed an affidavit to that effect. I would file an affidavit to that effect.
Direction for affidavit.
No, there was a direction upon the state to file report on affidavit.
That is done.
My learned friend for
Exception done.
petitioner.
My last question.
He is the selectee private respondent.
I am the
Now he is coming up to file exception to my, I am in your favor though, you are selecting.
I have filed an affidavit to bring on record that.
Oh, all the documents
all
that
the
he wants.
You want to file an affidavit?
Affidavit.
Right, তাই তো কথা. So it will be an opposition
Then
to the petition. কি বললাম? So you file a report on affidavit. Extended now. On the prayer of Mr. Baral, private respondent number 5 shall file an affidavit. In opposition. On or before. September 16, 2025. Paragraph, the petitioner shall be at liberty to file affidavit in reply thereto, on or before. November 10, 2025. The writ petition shall appear under the heading কিসে আছে? For orders. On November 19, 2025. ততদিন নিশ্চয়ই পাল্টে যাবে। None appears for the parties.
I was responding.
Yes, sir. You are for?
I'm for the petition.
What is the matter?
Lordship, here, initially the VR has been accepted and subsequently VR has been withdrawn.
Huh?
Initially the VR has been accepted.
VR?
Voluntary VRS. Has been accepted, but subsequently within the notice period, the VR has been withdrawn. But that has not been intimated to the employee.
You have filed affidavit?
Yes, Lordship.
Report has been
Report filed?
No, today I'm filing it, Lord. Today I'm filing it, Lord.
Are exception to come after vacation?
Service.
What are the two?
Affidavit service, Lordship. Affidavit of service. Oh, sorry.
Affidavit of service. Respondent affidavit of service দেবে।
report up to.
I'm filing the report. I have served on a copy of something.
And the list of date, your Lordship has directed to file the list of date also.
কি বললাম? লিখুন। Mr.
M. Ghosh. Mahadev Ghosh.
Mahadev Ghosh. Ghosh.
Yes.
Mahadev Ghosh, landed advocate, appears for the petitioner. Mr.
KP Chatterjee, Lordship. KP Chatterjee.
KP Chatterjee, landed advocate, appears for
Union of India.
Union of India. Paragraph. On the prayer of the learned counsel for the Union of India, time to file report in the form of affidavit stands extended till today. Full stop. The report filed in court today is taken on record. Full stop. Copy has been served. Paragraph. Identically, the affidavit in reply to the report filed by the petitioner, filed on behalf of the petitioner, today in court is also taken on record. Full stop. The writ petition shall appear under the heading কিসে আছে? For orders. On November 19, 2025. Next.
Milord, may I pray for indulgence, Milord? One problem has cropped up in item 14. Report on affidavit by the state has been served upon the parties, but original has not yet been filed with the Honorable Court. Now today, Milord, I find this junior, he has not come, he is in the trend now. The original lies in his custody. May I give the in course of the day if I file?
On the next day you file. Exception filed, who will deny? Not to worry. I will make a formal order, I'll take it. If I'm there.
Should be.
No, after vacation.
Apply for the petition in this matter, my lord.
After vacation.
My lord, only I have a problem, my lord, because item number 16 and 17, my lord, there are identical issues, my lord. So when 17 was called on, my lord, when the 17 was heard on the previous day, your lordship granted unconditional and indefinite stay. It's the same issue involved. The rules are different. One for the executive, 16 is for non-executive, and 17 is for executives. In 16, there is a limited stay, I suppose. And in 17, there is an indefinite stay. So we cannot proceed with the stay, with the disciplinary proceedings. The issues are same and identical, my lord. The point involved is same. That's why your lordship was pleased to fix this matter, 17 with the 16 on the same day. So I pray, my lord, the stay may be for a indefinite, not for an indefinite period. Otherwise, no,
You
then
come up with
otherwise,
an
my lord,
application.
no, my lord, we didn't want to, my lord. Why, my lord? Because your lordship on the last occasion,
The reason, sir, you come up with an application.
your lordship on the last occasion, may I only, my lord, have your lordship's 1 minute time, my lord. On the last occasion, my lord, when I intended to,
Sir, if I hear you, I don't mind. I will not be able to reach motion. 15 days, this court will not be available.
I understand, my lord, the problem.
So only 10 days, 7 days or 8 days this month, 10 days in the next month. If you wish, I can take up hearing matter. I don't mind.
Because I have only that problem, my lord, an indefinite stay. And because on the last occasion, your lordship, that's why your lordship said,
Past, I will see.
no, my lord, I am not asking for vacation.
I like that.
My lord, the trouble I'm facing, my lord, because on the last occasion, when the matter was taken out, my lord, taken up by your lordship, when I intended to show certain judgments, my lord, your lordship said that I'm fixing it on this 28th. Nothing will happen in this. I said, very well, my lord, it's 1 month.
With the hearing.
And that's why, my lord, only. That's the problem.
Fine, sir, how does it matter to me? I will not be able to reach motion. Proceed.
ইনডেফিনিট স্টে নিয়ে বসে দেখো জজ সাহেব করে দিলেন ইনডেফিনিট স্টে করে দিলেন আমাদের কোনো অসুবিধা
সে বলছে মোশন গুলো হবে না, আমাদের মোশন হবে না।
I have not
Proceed.
option point.
Proceed, sir.
16 and 17. 17 and 5. Proceed. Mr. Ghosh is to initiate.
Let him proceed to section 17, my lord, the item number 17. 16, my lord, I have taken point, my lord, of jurisdiction, my lord. The jurisdiction point your lordship has to listen.
I will hear that. Everything I will hear. Not to worry. Take out, say, proceed with 16.
16, my lord, I will need required time, my lord. I'll take time, my lord. Tomorrow, my lord, I cannot get myself ready, my lord. Only, my lord, 2 feet at that.
But the interim, so what will happen to the interim order?
The order, my lord, is not a
Then I am extending till disposal.
my lord. Then let me.
My lord, let them, my lord, file affidavit, my lord, in the meantime.
Take microphone.
Let the, my lord, then, my lord, let your lordship here.
Take the microphone.
Your lordship here, 17 first, my lord. 17 first, my lord. My lord, the issues are same, my lord. Here, my lord, departmental proceeding is supposed to be, my lord, state, my lord, over here, my lord. Let your lordship first here, 17.
Sir, if you take the point of jurisdiction, territorial jurisdiction, then
But then
like
let me
that has to be heard first.
My lord.
That has to be heard first.
But my lord, then, my lord, take it up. I am moving, my lord. Tomorrow I came from Asansol, my lord, so not get.
That's fine. Then come up after vacation.
Tomorrow, my lord, I can.
No. Come up after vacation.
But then, my lord,
Come after vacation. I don't mind.
kindly see, my lord, for me, my lord, another matter will get prejudice, my lord. I am proceeding, my lord. I am proceeding with. But my lord,
The same jurisdiction territorial point is there.
I have not taken any jurisdictional point.
That's right.
I have not taken any point. Mr. Arafin has taken a point. He will argue on that point. On the other issue, whether departmental proceedings.
So your one can be proceeded without jurisdiction point.
Jurisdiction, I have not taken.
So I'm hearing it, I'm extending your interim order till disposal.
my lord. My lord.
In the meantime, if the interim order lapses, then what will happen?
Lordship will fix the matter, my lord, on. Your lordship is fixing after vacation, but a particular date.
Of course. But till when the interim order is there?
Till, my lord. July 3rd was there, my lord, at the top, and interim till
July 10th.
10th July.
Till July 10th.
In
Yes,
July.
but till July
So interim order has already expired.
So thereafter extended, my lord.
When? Show me.
Thereafter extended, I suppose.
Thereafter extended, there is two orders.
Show
my
me.
lord.
Show me.
Well, order dated 4th July 2025. If your lordship kindly see, your lordship is
14th
extended.
July.
My lord, 4th July.
Yes.
Your lordship is extended.
19th June.
Yes.
Until the preliminary point, as indicated herein, is finally decided.
My lord.
So if he does not want to proceed,
No, my
let him
lord,
not proceed.
Let me proceed related to time. The preliminary point, my lord, I am just arguing. But preliminary point, I am arguing. Jurisdiction point.
Argue.
But kindly first see, my lord, the petition, my lord.
WPA. ভালো হয়েছে ধীরে ধীরে শুনুন আমার কি দাঁড়া আছে
But initially, my lord, when your lordship has taken up matter, my lord, they did not raise the point of jurisdiction.
matter it is
Your lordship,
I can raise.
yes, my lord.
But if your lordship opens the writ petition first, my lord, kindly see, my lord, the address of the petitioner, my lord. But may I proceed first, my lord?
My lord, may I proceed because my writ application, my lord.
Yes, you proceed. You just tell me the relevant facts for
Yes.
deciding jurisdiction.
Yes. And I have some judgment so that, my lord, I can place your lordship, my lord.
And for that, he has to place his jurisdiction point first. Otherwise, how will you place your judgment? Unless he takes.
Last day, my lord, friend has raised, so accordingly, I prepared the judgment, my lord.
Yes, you will.
My lord.
You will place.
My lord.
I welcome everybody, not
Very
to
well.
worry. But let him say what he want to say.
Very well, my lord.
Acha, let us read the order records. Let us read the order. Read the order. Read the order.
Order, my lord, order passed by your lordship.
4th of July.
July. Just a minute. Order আছে তো
ধরুন
affidavit service by the court is taken on record. The petitioner is
July, 4th July.
19th.
My lord, read, my lord, may I read, my lord, 19th July first, my lord?
4th July, the jurisdiction points.
July depart.
Mr. Ghosh, learned advocate, appears for the petitioner pursuant to the directions made by this court on 19th July 2025. The supplementary affidavit filed by the petitioner today in this court is taken on record. The copy has been served upon Mr. Arifin, learned counsel for the coal company. Today at the threshold, Mr. Arifin, learned counsel, submits that this court has no territorial jurisdiction to entertain and adjudicate upon the writ petition. In support, he submits that writ petitioner is working with the relevant coal company at Jharkhand, having been posted there. The relevant complaint was lodged at Jharkhand. CBI has initiated criminal proceedings before the CBI court at Jharkhand. The relevant employer coal company has issued the relevant charge sheet dated such and such from its office at Jharkhand. The inquiry officer is conducting disciplinary proceedings at Jharkhand. Per contra, Mr. Ghosh, learned counsel for the petitioner, submits that the sanction for prosecutions by virtue of the letter dated such and such as mentioned under the Annexure 3 against serial number 6 thereof at page number 28 to the writ petition has been issued from the headquarters of the relevant coal company at Sanktoria within the territorial jurisdiction of this court. Showing the document from page number 49, 52 and 53 to the writ petition, Mr. Ghosh submits that the part cause of action arose within the territorial jurisdiction of this court. Hence, this court has jurisdiction. Mr. Ghosh submits that he shall cite relevant judgment on the issue on the next day. Mr. Arifin also submits that on the basis of the relevant judgment on the next day, the writ petition shall appear such and such. It is made clear that on next day, the point of demur shall be heard and decided first. Interim order passed by this court on such and such shall extended until the preliminary point as indicated herein is finally decided by this court.
So you argue? Yes, Mr. Arifin. You first show whatever judgments you want to cite. Then he will cite his judgment. He will distinguish your judgment and you will distinguish in reply his judgment. Simple.
Kindly come to honor.
সারাদিন ধরে শোনা যাবে গুছিয়ে কোনো ব্যাপার নেই চলো
Motion matters are there.
Yes.
Yes, madam. First, kindly see, madam. 2004-9 SCC,
আমার
madam.
আজকে দুটোর পর তো ডিভিশন বেঞ্চ আছে চলো ইয়েস
2004-9 SCC, my lord. Page number 786. But this, my lord, define, my lord, what is cause of action, my lord. 2004-9 SCC 786.
Slowly.
But para 9 onwards.
আমার ইয়ে নেই তো নোটের ফাইলটাই The respondent এটা পিটিশন, তো রেসপন্ডেন্টেরটাই ঢুকবে এখন। দাঁড়ান দেখি, আর এইটা নোট ফাইল বানিয়ে দেবে। দাঁড়ান হ্যাঁ দেখি ঢুকবে। হ্যাঁ ঠিক আছে, রেসপন্ডেন্টেরটা তুমি রেসপন্ডেন্টের পিটিশনারটা বের করে নাও, ফাইল দুটো এক্ষুনি লাগাতে হবে না বাবা, আমি পড়ে নি তারপর লাগাবে। তুমি রাখো দুটো, পিটিশনার আর রেসপন্ডেন্টের ফাইল লাগো, যেটা যখন বলবো লাগিয়ে দেবে, ঠিক আছে? এইসব ফালতু ছাড়ো, এটা সাপ্লিমেন্টারি, দেখি দেখি দেখি।
But para 9 orders, my lord.
Wait, Mr. SN RFN. Yes, show me.
Mr. Kirti N. Rebel, Learned Senior Solicitor General.
2004 9 SCC
786.
Paragraph
910. 11, 12. 19, 11, 12.
Yes.
Sri Kirti N. R. Rebel, Learned Senior Solicitor General, appearing for the appellant, has seriously urged that no part of the cause of action has.
One second. Feeling agreed with by the judgment and order. Take the microphone. And then you read.
Yes, my lord.
Yes, read.
But Learned Solicitor General, appearing for the appellant, has strenuously urged that no part of cause of action has accrued in Calcutta, as the textile mill was situated in Bombay and supply was to be made factory in Bombay, and the alleged payment of the. But para 9, para 9.
9.
Para 9.
Oh, you start from 8. You said you start from 8.
Okay. Feeling aggrieved by the judgment and order of the learned single judge, the writ petitioner preferred an appeal before Division Bench of Calcutta High Court. The Division Bench held by the Calcutta High Court had the jurisdiction to be heard the matter on part of cause of action accrued therein. On merit, it was held that ordinarily a writ of mandamus cannot be issued for specific performance of contract, yet there is no absolute bar on doing so. This page went on to hold that whether the fact that existed the contract or not would be the question of fact, and having regard to the fact that the state has a statutory duty to perform the contract, the appeal was disposed of with the following direction. Or the direction was given that in this situation, the nature, we are of the opinion that the interest of the justice would be subserved if the present improvement of the post of chairman cum managing director, giving an opportunity of hearing to the petitioner.
Different issue.
Different issue. It's a 9.
9.
My lord. But the Learned Solicitor General, appearing for the appellant, has strenuously urged that no part of cause of action had accrued in Calcutta, as the textile mill was situated in Bombay and supply was to be made factory at Bombay, and the alleged payment of the writ petitioner was also made in the said place. It is thus being urged that it is not a case where even a part of cause of action may be accrued in the state of West Bengal, and would be enable the Calcutta High Court to enter the writ petition and to grant the relief to the writ petitioner. Mr. Such and such, senior counsel appearing for the respondent hearing, had submitted that the writ petitioner was carrying on business at Calcutta. The letter was sent by them from Calcutta, and reply to the same has also been received by the Calcutta, and therefore the part of cause of action has accrued in state of West Bengal, and consequently in view taken by the division bench, the Honorable High Court, that it has jurisdiction to entertain a writ petition was preferred correctly. Under clause 2, now this is the observation, under clause 2 of Article 226 of the Constitution, the High Court is empowered to issue writ, orders or direction to the government authority or person exercising jurisdiction in relation to territory within which the cause of action wholly or in part arises for the exercise of such power, notwithstanding that the seat of such government, the authority or the residence of such person is not within the territorial jurisdiction. Cause of action as understood in CPC, in the civil procedure, means whenever every fact which travels would be necessary for the plaintiff to prove in order to support the right to a jurisdiction of the court. To put it in a different way, it is a bundle of fact which takes when the law applicable to them, given the plaintiff the right to relief against the said defendant. Union of India and such. In this context, clause number 2 of Article 26 of the Constitution of India, it has been explained that each and every fact pleaded in the writ petition does not ipso facto lead to the conclusion that those facts give rise to the cause of action within the court's territorial jurisdiction, unless those facts pleaded are such which have a nexus or relevance with the lease that is involved in the case. Facts which gives no bearing with the lease or dispute involved in the case does not give rise to a cause of action, so as to confer territorial jurisdiction on the court concerning. A similar case has been explained in such and such. Hearing content properties belonging to a company which has a registered office in Calcutta were sought to be acquired in Jaipur, and a notice under Section 52 of Rajasthan Urban Improvement Act was served upon the company at Calcutta. The question which arose for consideration was whether the service of notice at the headquarters of Company of Calcutta would give rise a cause of action within the state of West Bengal to enable the Calcutta High Court to exercise jurisdiction in a matter where challenge to acquiring proceeding concluded in Jaipur was made. It was held that the entire cause of action culminated in the acquisition of the land under Section 152 of Rajasthan Act arose within the territorial jurisdiction of Rajasthan High Court, and it was not necessary for the company to plead that service of notice upon them at Calcutta was for grant of appropriate writ order or direction under Article 226 of the Constitution for causing of notice issued by the Rajasthan government under Section 52 of this Act. It was also held that the Calcutta High Court had no jurisdiction to enter the writ petition. This question of jurisdiction was considered in considerable details in Oil and Natural Gas Commission versus such and such, and it was held that merely because a writ petition submitted a tender and made representation from Calcutta in respect of the advertisement inviting tender, which was to be considered at New Delhi, and the work was to be performed at Gujarat, Hazira, Gujarat, and also receive reply and fax message in Calcutta, would not constitute fact forming an integral part of cause of action. It was also further held that High Court could not accumulate jurisdiction on the ground that the writ petitioner deciding or carrying out business from the residence office of the state of West Bengal. In this present case, the textile mills are now dealing with this, my lord, where it was there, my lord. So, my lord, substantial cause of action has to be there, my lord, in a particular jurisdiction. Only that court will have jurisdiction, my lord. This case indicate to that point, my lord. Now, my lord, if your lordship
now, according to Mr. Ghosh, kindly come to the order.
Yes, my lord.
He says that the sanction of prosecution by virtue of a letter dated November 25, 2025, as mentioned under Annexure 3, again serial number 36 thereof,
yes,
at page 28 to the writ petition has been issued from headquarters.
My lord, but my lord, the disciplinary proceeding, my lord, where the offence has happened, my lord. Everything has happened, my lord, in the jurisdiction of Jharkhand, my lord. My lord, the residence of the person are also in Jharkhand, my lord. My lord, the offence which had happened, my lord, in the office of Jharkhand, my lord. My lord, the CBI inquiry which is going on, my lord.
Admittedly, everything had
Everything
happened.
is happened over there.
Whether the issuance of this sanction, will it constitute a cause of action?
But this judgment which I showed, my lord, it also said, my lord, that the company has a registered office over there, my lord, and tender was issued from there, my lord. That would mean, my lord, that the cause of action goes there, my lord. Yeah, my lord, only giving sanction, my lord, the sanctioning authority is the my lord concerned headquarters. my lord.
Yes, read that part once again. Paragraph 10.
Under clause 2 of Article 226 of Constitution, the High Court is empowered to issue writ, orders or direction.
No, kindly come to the last part, the question which arose for consideration.
The question of jurisdiction, my lord, para 11.
No, last 10 lines or something.
Achha.
The question which arose for consideration.
Yes, the question which arose for consideration was whether the service of notice at head office of company at Calcutta could give rise to cause of action within the state of West Bengal to enable the Calcutta High Court to exercise jurisdiction in a matter where challenge of acquisition proceeding conducted in Jaipur was made. It was held that the entire cause of action culminated in the acquisition of land under Section 152 of Rajasthan Act arose within the territorial jurisdiction of Rajasthan High Court, and it was not necessary for the company to plead the service of notice upon them at
It
Calcutta.
was not necessary for the company to plead.
But it was only pleaded to
service of
bring
notice.
jurisdiction. My lord.
So it had gone, the Supreme Court had gone on culmination of proceeding.
My lord. Whereas the culmination of proceeding had happened. Where, my lord, the lease is pending. I will say rather, my lord, where is the lease is pending? It is not necessary for the company to plead the service of notice upon the Calcutta for granting appropriate writ, order or direction under Article 226 of the Constitution for the question of notice issued by the Rajasthan government under Section 52 of this Act. It is thus held that Calcutta High Court had no jurisdiction to enter into the
Wait. Now read 11. 11.
The question of jurisdiction was considered in considerable details in Oil and Natural Gas Corporation on Utpal Kumar Basu. It has been held that merely because a writ petition submit a tender and made representation from Calcutta in response to an advertisement inviting tender, which was on to be considered at New Delhi, and the work was to be performed at Ajaraya, Gujarat, and also received replies to the fax message at Calcutta, could not constitute the fact forming an integral part of cause of action. It was further held that the High Court should not assume jurisdiction on the ground that the writ petition presiding or carrying on business for a residential office in the state of West Bengal.
Yes.
Next, my lord, in the present case, the textile mill is situated at Bombay, and the supply of cloth was also to be made by them ex factory at Bombay. According to the writ petitioner, the money was paid to the mill at Bombay. The learned single judge, after a deliberate discussion of the matters, held that the Calcutta High Court has no jurisdiction to enter into the writ petition. The division bench has reserved the finding on the ground that the concluding contract had come to the existence, which could be cancelled only at the given an opportunity of hearing, and consequently the question of revocation of the contract of the Calcutta address would be considered as cause of action. In our opinion, in view of that view taken by the division bench is wholly erroneous in law. It was nowhere pleaded in the writ petition that the appellant herein has invited any cause of action in section 11 of this act by issuing a notice to the writ petitioner for cancellation of contract. In fact, it is stated that in para 18 of the petition of the central government did not follow the procedure prescribed in section 11 for cancellation of contract. Rather, the jurisdiction of Calcutta High Court for the reverse statement was made in para 73 of the writ petition, wherein it has stated under that the petitioner is carrying on business on material all accounts, and the aforesaid place of business was the jurisdiction. The petitioner states that by a reason of the aforesaid, your petitioner had suffered loss and damages, and it was the place of business wherein the jurisdiction. All notice and correspondence referred to herein addressed to your petitioner has been received by your petitioner at the petitioner's place of business within the jurisdiction. In such circumstances, the Honorable Court has jurisdiction to enter the present application. As discussed earlier, the mere fact that the writ petitioner carried on business at Calcutta and that the relying on the correspondence made by it was received in Calcutta is not the integral part of the cause of action, and therefore the Calcutta High Court has no jurisdiction to enter the writ petition, and the view of that contrary taken by the division bench cannot be sustained. In view of that above finding, the writ petition is liable to be dismissed. However, in order to avoid further harassment to the parties and to put the end on the litigation, we would examine the matter on merit as well. That is on merit thereafter it is going on. So the cause or the least has to be the integral part. The cause of action, it has to be an integral part. Here in this matter, if your lordship sees the writ petition, if your lordship can please come to the writ petition first, your lordship will find, the person who is making this writ petition have residence at Jharkhand. The cause of thereafter the charge sheet issued page 24 your lordship find charge sheet has been issued the disciplinary authority. If your lordship find the writ petition or
charge sheet
it
is respondent file
page 24
First you show me which page.
First, I want to show the cost title. Cost title, kindly see the residence of the Gauramani who is making this prayer. Yes, that is cost title. Thereafter, your lordship goes to page 24, the charge sheet.
Page 24.
Oh, before that, kindly come to the prayer. Prayer is 21. Or what is his prayer before your lordship? Integral part. The prayer is the writ in the nature of mandamus, commanding the respondent authority, including the man and agent, subordinate, servant, successor in office, to stay the disciplinary proceeding and the inquiry initiated by the respondent authority arising out of charge sheet of ECL dated such and such 6/2/2025 till the criminal proceeding are concluded forward.
So my criminal proceeding is also
there
in Jharkhand.
Charge sheet
page.
Charge sheet at page 24.
24.
But this is under challenge charge sheet issued by the disciplinary authority and agent Sampur B. Colliery, Mugma area. Mugma area is at Jharkhand admitted . But your lordship will also find, the address given.
Wait.
And you see, it has been issued by Mugma area.
It was issued from?
From Mugma area. Mugma area is at Jharkhand.
Where do you get?
Mugma area at Jharkhand, Eastern Coalfield Limited. But address, your lordship is asking for address.
Yes, Mugma.
The
disciplinary authority
and agent.
And agent. Mugma issued to Mugma.
Yes, my lord. It's a particular colliery, Sampur B colliery, Mugma area. Now, my lord, offense had also happened, there only, my lord. My lord, kindly comes to my lord, para page 31. Page 31, my lord. Page 31 is the, my lord, the complaint which has been lodged, my lord. Or rather, my lord.
Yes, complaint. It's dated.
Rather, my lord, the complaint is, my lord, at
Date.
11/9/2019, 2024. Page 34A, my lord. Can you come to page 34A? That is the complaint, my lord.
34A,
my lord. This is the first complaint given by MD Salim, my lord. Kindly see, my lord, where the complaint was made. To the Superintendent of Police, my lord, CBI, Dhanbad. And my lord, kindly see, my lord, name, my lord, of the complaint is also there, my lord. And my lord, against my lord, the General Mazdoor, my lord, my lord, here, my lord, the manager was first impeached, my lord, thereafter this person was impeached. Now, my lord, kindly come to page 24 again, my lord. This is, my lord, the CBI, my lord, is writing, my lord. CBI made investigation, my lord, and thereafter had caught red-handedly. Now, the complaint was initially against a manager. The complaint 24, my lord. Complaint was initially against a manager, my lord. But manager was very clever, my lord. Manager did not take the money directly.
But that doesn't matter. So it appears charge sheet at Jharkhand.
Yes, my lord.
Then
charge sheet at Jharkhand, my lord. This is, my lord, the CBI, my lord, as my lord, prima facie satisfying, my lord, has given, my lord, this letter, my lord. This is also, my lord, the page 24, my lord, page 24. Page 24. Sorry, my lord. Charge sheet কোথায় আছে? Charge sheet হলো, তারপর offense happened in,
Hey, Rajiv.
Page 43, my lord. 31.
Page
31.
31. What is that?
This is also a letter, my lord, given, my lord, by the Dhanbad, my lord, CBI, my lord. Kindly see, my lord, MD Salim, General Manager of Shampoo B. Colliery, Eastern Coalfield Limited, Mugma area, Nasi, Dhanbad, has had his complaint dated such and such. My lord,
what is this communication?
This communication, my lord, is my lord, made by the CBI, my lord. CBI of Dhanbad, my lord. That I want to show. Or other, my lord, your lordship, skip that, my lord. It's a little bit cryptic, my lord. Now, my lord, kindly comes to, my lord, page 40, my lord. Page 40.
40.
40.
What is that?
This is, my lord, the case, my lord, the criminal case where it is going on.
This is before the jurisdictional criminal court.
My lord. Criminal court. But this is the initiator, my lord, of our departmental proceeding also, my lord. He has done offense there, my lord. That complaint was made, so, my lord, our department proceeding had also started.
Yes.
Now, my lord, kindly comes to, my lord, page 45, my lord. 45 is the, my lord, written submission. Written statement made by the defendant.
That is neither here nor there.
But kindly see, my lord, where the written statement was filed.
What is this release order?
My lord. Page. But you lost your page.
49.
First, my lord, 45. Kindly see, my lord, where he is given his written statement, my lord. The person, the petitioner, my lord, is given his written statement.
45.
45.
What is that?
Where he is giving his written statement, answering our discipline proceeding, my lord. His representation against our disciplinary proceeding. But before the disciplinary authority and agents, Sampur B. Colliery, Mugma area is here. That is also at Jharkhand.
Admittedly, the proceeding is pending at Jharkhand.
Yes, my lord. Yes, my lord.
That, now kindly see these pages. 49, 52, and 53.
49, 57, 48, 49. Now, my lord, here, my lord.
49 is the release order, nothing. 52.
52, my lord, is, my lord. 51, 52.
48,
52 is,
48
my
and
lord,
49 relevant, my lord.
49 is not, you will make your submission.
52, my lord, Gaur Ramani, my lord, for Gaur Ramani, my lord, it is given by agent, my lord. That is also, my lord, this group of minds is also at Mugma, my lord.
Mugma.
Or kindly see, my lord, the heading.
What is
heading,
this?
Heading, my lord, kindly
Oh,
see
52 is what?
52, my lord, is, my lord, the persons to later dated such and such. Commented that inquiry officer, the preliminary hearing of schedule on Thursday, June 5th.
Absence.
But he was absent, that's why a preliminary hearing was scheduled on Thursday on such and such at 11th Vigilance Department at
Then
House, my lord.
53.
Yes, my lord. 53, my lord, is, my lord. Kindly see, my lord. This is the
Order sheet
order sheet, my lord.
of the disciplinary proceeding.
Disciplinary proceeding.
All right. I'm coming within 10 minutes. You have any further judgment?
My lord.
Huh? All right, I'm coming. You show me. Then I will hear you.
Calcutta
2013
13
2013
SCC online Cal
what's it? Slowly
SCC
online Cal
10678
10678
678. Here, my lord, your lordship comes, my lord. This judgment does not have paragraph number, my lord. 2013 SCC online Cal 10678. But kindly comes to, my lord, the first page, my lord, the paragraph starting at last, my lord. Just to show that what was the issue.
Show me.
The respondent having taken preliminary point, you also got it.
Kuda.
First page, my lord, last paragraph.
I've taken.
The respondent having taken a preliminary point and objection on the ground of lack of territorial jurisdiction of a court for entertaining a petition. The point as such was heard as a preliminary point, and the affidavit filed by the respondent number 225 is restrained to the question of preliminary objection alone. The respondent case is that the charge sheet dated May 18, 2004 was issued by the agent of Bastimata Colliery, which is in the state of Jharkhand. The explanation submitted by the petitioner was considered by the agent being the disciplinary authority, and the regular department proceeding was also communicated, continued, and concluded as Bastimata Colliery, which is outside territorial jurisdiction of the territorial jurisdiction of this court. Accordingly to them, no part and cause of action has arisen within the territorial jurisdiction of this court, and as such, the court has no jurisdiction to entertain this petition. Now, my lord, kindly comes to my lord. Here, my lord, why I am showing, my lord, here, my lord, several judgment was considered by the court, my lord. But my lord, similar thing was there, my lord. Your lordship will start, my lord, from my first, my lord. Kindly see, my lord, at that paragraph, my lord, the last paragraph.
Sonic.
The Supreme Court in the case of Sonic Sajid Company Limited held that the context that in Section 17 on Consumer Protection Act, that it was well settled that the expression cause of action means a bundle of fact which give rise to a right and liability. In this case, the fire broke out at Ambala, the insurance policy was taken at Ambala, and the claim for compensation was also made at Ambala. As such, no part of cause of action arose at Chandigarh. The Supreme Court had approved the view taken by the court in the case of such and such of Union of India reported in year 2003, Cal 8. In such a case, the division bench of this court has held that the relief as prayed of the court could not be granted by the court. On the argument of the case of Sonic Surgery was also one of the branch of office of Chandigarh, and health complaints could not have been filed in Chandigarh as well. Now, my lord, your lordship, now next page, my lord, the question, my lord, in middle, my lord, the question of cause of action come. This is part in connection to Eastern Coalfield Limited, my lord. Your lordship, find what the next page, my lord.
Yes, I got
the question come. The question of cause of action also came in consideration before the Supreme Court in a case Eastern Coalfield Limited versus Kalyan Banerjee, reported in 2008-3 SEC 456, where it has been held that after consideration of several cases and cause of action for the purpose of Article 226 of the Constitution of India, of all the intel and purport has been assigned and made in the same meaning emphasized that under Section 20C of the Code of Civil Procedure Code, it means a bundle of fact which is required to be proved. But the entire bundle of fact pleaded need not constitute the cause of action, as what is necessary to be proved is a material fact whereupon the writ petition can be allowed. Now, in this case, the respondent before the Supreme Court was an employee of Eastern Coalfield Limited in Mumbai area, in a district of Dhanbad. The general manager of that area, whose office was also situated, there was an appointment of disciplinary authority. The service of the respondent was terminated by MUGMA. Here was also the same thing. He filed a writ petition before the Honorable High Court at Calcutta. A preliminary objection was raised regarding the jurisdiction of Calcutta High Court. The division bench, by a judgment and order held in the High Court had no territorial jurisdiction to entertain a writ petition, but subsequently on an application for review, the division bench has changed its view and had held that the employee challenged the order of dismissal. You cannot get an effective order unless the employee is made party to the litigation. And in this case, the Eastern Coalfield Limited have been registered office in the district of Bardhaman was necessary party. The High Court had held that even if the cause of action arose outside the territorial jurisdiction limit of the High Court could still entertain a writ petition if the person sought to be bound by the order is sanctioned within the territorial limit. Reversing this view and relying on this earlier judgment in case of Kumari Signet versus Alloys Limited, the Union of India, reported in such and such, and various other cases, Supreme Court held that in view of the decision of High Court that the entire cause of action arose in Mugma area within the state of Jharkhand only because the head office of the respondent company is situated within the state of West Bengal, the same will not confer jurisdiction upon Calcutta High Court when the head office has nothing to do with the order of punishment passed against the employee. But here the punishment will be given by the disciplinary authority. But maybe the sanction has been given by headquarters. But the integral part is giving punishment to that person, whether he will get punishment or he will be acquitted. That will be done by the disciplinary authority, who is of Mugma area, that I have shown to your lordship. Now, my lord, if your lordship comes thereafter, not. My lord, last on that page, my lord, last paragraph.
We have referred to already. Last page.
Yes,
the last paragraph.
Last paragraph.
Adani.
In case of unit, yes, Adani.
He has already placed Adani.
But here, my lord, it is saying about the list and nexus, my lord. Now, my lord, if your lordship wants, my lord, then I can also I also have that, my lord, Kalyan Mukherjee, my lord, but my lord, it is stated over here, my lord. Now, my lord, only one thing which my learned friend will argue, my lord, that is, my lord, he will show, my lord, your lordship, my lord, the venue, where the departmental proceeding will take place. That venue, my lord, is at Sitarampur, which is within this territorial jurisdiction. Can you come to that later, my lord? That is, my lord. Page. My lord, that is at page 44, 49. No.
40?
49.
49.
Here, my lord, the venue is fixed, my lord, at my lord Sitarampur. But here the vigilance, my lord, the venue where, my lord, the departmental proceeding will be taken place, my lord, is, my lord, at Sitarampur. This, my lord, form, my lord, within, my lord. Now, my lord, here, my lord, kindly see, my lord, who is issuing managers, Sonpur Bajar process, but who is the issuing authority?
Venue will have no bearing.
Yes, my lord. That, my lord, only is it. But main thing is, my lord, where, my lord, disciplinary proceeding has been taken place, but where it will be held, my lord.
Initiation.
Yes, my lord.
Initiation, proceeding, and the suffering of punishment where?
Right. There.
It is the working place.
And even offense, my lord, where it has happened, my lord, in criminal jurisdiction, your lordship knows, my lord, where the offense happens, my lord, that is the territorial jurisdiction. That place will only have the jurisdiction, my lord. For that, my lord, Dhanbad is also having the jurisdiction. So these are my limited submission, my lord. Your lordship, here, Mr.
If you wish, you can come tomorrow. Tomorrow, Thursday.
21st.
Come tomorrow.
My lord will be taking 17 also tomorrow.
Yes.
If your lordship is pleased to take it up on Friday. If your lordship is pleased to take
Friday is a contempt day.
Then Monday, my lord.
Monday, too many matters are there. Come tomorrow. This matter I will keep along with that. But first, let me decide this. Then I will take up that. Whether I will take up that or not, I will decide then. Because I have to reshuffle the list.
Very well.
Mr. Partha Ghosh, Learned Counsel, appears for the petitioner. Mr. S.N. Arifin, Learned Counsel, appears for ECL. Poster. Mr. Arifin has concluded his submissions on the preliminary point of maintainability of this writ petition on the ground of territorial jurisdiction. He has placed two judgments. Poster. Paragraph. Mr. Ghosh, Learned Counsel for the petitioner, shall commence his submissions tomorrow. And he shall also deal with the submissions of Mr. Arifin only on the point of maintainability.
Only one thing may kindly be recorded, that they will not, my lord, file any affidavit with regard to, my lord, the maintainability point. That may kindly be recorded, because they chooses not to file any affidavit, because all the matters, when, my lord, they have taken in the ECL matters which have been submitted by learned friend, here that was decided upon affidavit. So let it be recorded that they will not, my lord, file any affidavit on the point of
Appearing for the coal company submits that on the issue of maintainability,
I will not.
ECL shall not file any affidavit. But if the maintainability point does not succeed, then he shall file affidavit on the merit of the writ petition. Okay. Paragraph. The writ petition shall appear under the heading kishe ache? For orders. এখানে কোনো আগে অর্ডার হয়েছে? আজকে কোনো অর্ডার হয়েছে? For orders, first. কালকে, হ্যাঁ, for orders on কাল কত? August 21, 2025. Even if you don't get the order, it is understood tomorrow matter will
Yes,
be
yes, yes. I am here, my lord. So appearance, my lord.
Poster. Come tomorrow. Make your
17 also same, my lord. 17 also same.
Simply I am passing it over for tomorrow.
No.
Cannot be the same. No, that order cannot be the same.
Next matter passed over for the day. Passed over for the day. আর কালকে আমার সঙ্গে না এদিকে দেখো কথা বলে নেবেন, লিস্টটাকে রিসাফল করব।
ওই দিলাম তো।
Next one, I have passed it over. 17. Yes. হ্যাঁ, ওটা রেখে দাও তো। আজকে আমার সঙ্গে দিদি দেখা করবেন, আজকে লিস্টটা রিসাফল করে দেবেন, প্রশ্নগুলো সামনে নিয়ে চলে আসবো। কিন্তু যেগুলো আমি ডিরেকশন দিয়েছি কালকের ফর অর্ডার সেগুলো থাকবে, লিস্টে থাকবে, কিন্তু আমি এগিয়ে করে দেবো। সেটা দেখে নেবো, আপনি হ্যাঁ সেইভাবে করে নিয়ে আসবেন। অ্যাপ্লিকেশন দেখাবেন, অ্যাপ্লিকেশনটাও থাকবে। হ্যাঁ, না আমি বলে দেবো, আপনি দেবেন টু বি মেনশন, তারপরে অ্যাপ্লিকেশন, এই দুটো ফর অর্ডার্স, দুটো আজকের দুটো, এই দুটো 17টা, তারপরে মোশন, তারপরে আবার বাকি ফর অর্ডার্স কালকের যা ডিরেকশন থাকবে সেগুলো ফর অর্ডার্স। এটা তো ফর অর্ডার স্টপ করে দেবেন। Yes.
Lordship, in continuation of my all that submission, Your Lordship, I would like to add some points, Your Lordship.
Where?
The first point is that
this is motion.
Yes.
Dilip Kumar Mitro.
Dilip Kumar.
So you make your submission.
Yes, Your Lordship. On all the others, I have concluded my submission, Your Lordship.
In this matter?
Yes. The same
But
matter.
I was not there at that time.
My learned friend was not present that one.
And if my learned friend can
Please start it again.
Here, the petitioner has rendered his service for more than 30 years. Now, after completion of his most faithful service to the corporation, He retired sometimes in the year 2013. Now, he was the benefit being the employee of the corporation. He was entitled to get the benefits under ROPA, which was from time to time periodically was granted to all the employees of the corporation. Now, the petitioner, this particular employee, your lordship, was deprived of all the benefits of the revision of pay, which has been granted to other employees.
Take your seat, take your seat.
Now, the lordship, the total amount which has come at, as per the calculation, initial calculation, lordship, that will come rupees 20 lakhs. 20 lakhs. Now, after that, the petitioner has made claim to the corporation, but that was not granted. Therefore, the petitioner has made an application under Article 226 of the Constitution of India.
Under?
226 or Article 226 of the Constitution of India. And now he made claim of the said amount that was due.
The impugned order is passed at page 63.
Yes, lordship.
You are challenging that impugned order?
Yes, not only that impugned order, I prayed for that, the implementation of the calculation of the arrear, which has arrived at.
Which page is the calculation?
Yes, lordship. Detailed calculation was given at page starting from, that was as per direction of Honorable Justice Sambudhu Chakraborty.
Kindly show me the calculation, sir. Page 48.
Page 55, your lords, you can.
Page 55
onwards up to, that is continuous.
55 to 62.
62, yes. Detailed calculation has been given, month-wise. That is month-wise has been given. So that will come to around rupees 40 lakhs, 14 lakhs, sorry, lordship. 14 lakhs. That is not that the initial amount which was arrived at, that is 20 lakhs. After making necessary deduction and the amounts paid to the petitioner.
After adjustment.
Adjustment, yes, lordship. That amount has come.
Now you claim 14,66,978.
Yes, lordship. That is my own claim. After making all deductions.
At page 56.
Yes.
Okay.
Now, after that,
what is their stand? Show me from their report.
Yes.
Why they say that ROPA will not apply?
According to them, your lordship. Lordship kindly comes to paragraph 8 of their report. May I read, your lordship?
Yes.
Answering the solemn query of the Honorable Court by the order dated 2nd August 2023, showing how the payments has already held to be made by the recent order dated 29th May 2017 have been disbursed to the petitioner. It is stated that payment of 6 months arrear under ROPA 2006.
Paragraph 8.
8. Page 3. Have been expended in favor of the petitioner on 19 July 2017. An amount of rupees 41,036 has been disbursed in favor of the petitioner on account of 6 months arrear under ROPA 2006, along with 20% dearness allowance and increment arrear. That is admitted. We have admitted that that amount has been deducted from our initial amount. That is 20 lakhs, from 20 lakhs. The petitioner, having received the said amount in compliance of the order dated 29 May 2017, is stopped from questioning the validity and or legality of the said order. It's meaningless, lordship. It's meaningless. Our claim is 14 lakhs and it is, the amount is only 41,000. They have not spent a word about that 14 lakhs, the claim of 14 lakhs. Furthermore, from perusal of the writ petition, it appears that the petitioner has deliberately suppressed. How? I've already made a submission, Your Lordship, that is 41,000 has been deducted. That question doesn't arise at all, Your Lordship. That the petitioner has already received the said amount in his bank account way back in the 2017 itself, and that amount has been deducted, Your Lordship. It is therefore stated that present petition ought to be dismissed with cause for the reason of fraud and suppression. This is the word they have used. Let them just come up with that document that we have made suppression of fact. Nothing to show.
So that is the only defense they have taken.
Yes, that is only point. The 41,000 that has been already deducted, Your Lordship, from my calculation. Kindly comes to our representation,
Yes.
Your Lordship. It is absolutely, I have deducted that amount.
You show me how you have arrived at this figure.
Yes, Lordship, that's absolutely given details.
No, I'm not on calculation.
Yes.
I am on the application of ROPA.
Yes, Lordship, kindly. Yes, now, just on that point, I'll
You show me that how ROPA will apply.
I'm coming. Kindly comes to P2, which was obtained under ROPA RTI from the corporation, Your Lordship. That is the revised pay scale.
P2.
Revised P2.
Page
Revised pay
17.
scale, yes. That is revised pay scale, Your Lordship. That is a document of the corporation.
Yes.
Here, it is clearly laid down. Kindly, Lordship, come to paragraph 599.
Application of ROPA?
Yes.
ROPA what?
ROPA 1996. And now ROPA 1996, as per ROPA 1996, Your Lordship. Now, the first column, that is starting from 1/5/1996, Your Lordship. First column.
No. Page
At
17.
Yes.
1/7.
Yes.
1/7.
Yes, Lordship.
From
First
the
column.
repetition.
Yes.
It is like this.
I've got, Lordship, that table, one table is there. Yes, Lordship.
It
And the
starts
first column-
1/186.
Yes, that is common. That is not applicable here. We are the 1/5/1996 applicable. That is ROPA 1996 was applicable from this year, month, Your Lordship.
1st of May.
Yes, 1st of May. As per ROPA 1996, the fixation was 5450. The second column.
5450.
Yes. 5450. Now, Lordship, kindly comes to my pay slip, Your Lordship. That is at page 18, Your Lordship.
Page 18.
Yes, at the next page, the very next page.
Yes.
Lordship, kindly find May 1996. Here, Dilipwan Mitro, the basic.
Where is May 1996?
That is 1, 2, 3. In the middle, Your Lordship. May 1995, that is pay slip.
Where is May 1996?
That's in the middle, Your Lordship.
Yes,
Page 18. It is not clearly legible, though
Yes.
it is.
Your right is not legible.
It is not legible partly, but Lordship will kind of find here, Your Lordship, 1670 pay slip, continuously given 1670 is the pay.
I have to see.
Yes.
Where is that? I cannot see, sir.
That's definitely. Lordship, kindly take my. That month is not legible, Lordship.
Now, Dagdi. কোথায় দেবো?
And all the subsequent months, you'll also will find that there was no fixation.
Yes, there are.
Fixation.
Now show me what do you want
Yes.
to show?
There was no fixation as per the ROPA, your lordship. Continuously, the petition has been paid 1670. The next page 1670. That up to December, not only December, lordship, kindly comes to 20, up to page 20. That is also shows that 1670 has been given instead of 5,370. And now kindly comes to lordship page annexure P5. We will get page 48, lordship. That has been given at glance, your lordship. The difference, the pay scale between pay scale and the revised pay scale fixation. Page 48. It will be convenient, lordship. At a glance, your lordship will find that 1670 is the basic pay has been given. And whereas the petitioner was entitled
whereas it should have been 5200.
Yes, yes, your lordship. Yes. That is the difference. And that difference has been reflected in the detailed account given. Detailed account given.
So had this been considered, you are happy?
Yes, Lord. Yes. Yes.
Wait.
And
yes, madam.
Accordingly, that's a proportionate increment in our grade pay, PF, and all the
Where is your reasons?
My lord, I'll show it from the writ petition itself.
Take the microphone properly and.
My lord, I'll show it from the writ petition itself. My lord will kindly comes to page number 17 first. The page that the petitioner has relied.
1 second, wait. You take your seat, Yes, page?
Page 17, my lord.
17.
Yes. My lord, page 17 starts from 1st January 1986 when the petitioner was appointed. Thereafter, my lord, ROPA 1996, my lord will kindly. ROPA 1996, my lord, in the year 1/5/1996, my lord will see the column under promotion. Revised as per ROPA 96, the scale of pay is 3350 to 6320. Thereafter, my lord, cash benefit was provided. Thereafter, my lord, scale of store checker was allowed. Scale of superintendent was allowed. Revised thereafter again on 1st January 2006, the ROPA 2006 was allowed. Thereafter, my lord, pay was again refixed. So, my lord, this is the entire fixation of pay that the petitioner had been provided from the, my lord, corporation. Now, my lord, pertaining to this document, the petitioner has made his submission at my lord, page number 3, paragraph number 5 and 6 of the writ petition. My lord, may I read?
Wait.
Yes.
So you first took me to page 17.
Yes, my lord.
Then para?
Then, my lord, page number 3, paragraph number 5 and 6 of the writ petition.
Yes.
My lord, may I read paragraph number 5 and 6, my lord? That the office of the respondent number 3 has supplied the chart of revised pay scale of the petitioner as proposed and recommended by 3rd, 4th and 5th pay commission upon the requisite fees being put in by the petitioner. My lord, this is the annexure P2 that I just showed, my lord. That upon scrutiny of the chart of the revised pay scale supplied by the respondent number 3 and upon comparison with the pay slip salary sheet, the petitioner found that a huge discrepancy and anomalies in the scale of pay, particularly in the basic and proportionate variation in other benefits, dearness allowance, house rent allowance, provident fund, etc. In other words, to be more specific, the respondents did not disburse and rather deprived the petitioner for the actual benefit of ROPA of revision of pay and allowance proposed and recommended, particularly by the 4th and 5th pay commission. For example, ROPA 1996, the basic pay was fixed as at rupees 5,200 with retrospective effect from 1st January 1996, and there was proportional increment of dearness allowance, house rent allowance, provident fund, etc. But the transport authority continued to pay basic salary at the old scale, that is 1670 till the month of August 2000, which only with annual increment of rupees 50 instead of rupees 125 and rupees 150 payable in 2 segments over the interim period under the revised pay scale. The petitioner was at the same time deprived of career advancement scheme grade pay, which the transport authority had introduced for its employees as pay protection in lieu of promotion with retrospective effect from the month of May 1996 at a scale of 3600 to rupees 7050, which was later revised and replaced in the scale of 7100 to rupees 37,600. So, my lord, these are his submission with respect to this particular annexure. Now, my lord, the petitioner has compared page number 17 and my lord has shown that he has been paid only 1,617 rupees every month from 1996 till 2000. Now, my lord, relying upon the same salary sheet, my lord, may I bring my lord to page number 18 once? My lord will kindly comes to the same column, my lord, May 1996, that is. Before that, my lord, the column starts with March 1996, then thereafter April 1996, and the illegible one is May 1996. My lord will first kindly sees April 1996. The basic pay was 1630.
Yes.
Thereafter, my lord, May 1996, the basic pay went to 1670.
Right.
So, my lord, there was a revision of pay. Thereafter, my lord, will kindly seize the other columns. My lord, next to 1670, my lord will see
1670 up to July 96.
Yes, I'm only referring to May 1996 for the time being, my lord. My lord will kindly seize from May 1996 after 1696, just right after that, right side to 1696. My lord will see 2088. Then my lord will see
Where,
May 1996, the column that was illegible that the petitioner was referring to, my lord.
May, it is 1670. Basic pay.
Yes, the next column. After 1670, just the numbers after 1670, the next column.
2088.
2088. Then there is a subtotal, 3758. Then there, my lord,
3758.
Yes, my lord. Then there are other. This is Incent Canteen. My lord, there is a amount of 251. Then thereafter there is an amount of 72. Then there is an amount of 100. Then there is an amount of gross total, which is 4181. Then again there is an amount of rupees 30. Then there is an amount of PF com and PF volume. There is my lord, I'm just going in the right direction towards the right.
Yes, 30. Then 313.
313. Then my lord, ECCS 592. Then ED fine rupees 25, festive advance 50, then rent 1.
Then
My lord, then there is a deduction, total deduction. There is a deduction of 1325, and then there is a net amount of 2855.
yes.
So, my lord, 1670 is not just the amount. There are increments, there are deductions, and then there is the net amount. What the petitioner has done is he has only calculated 1670 and he has made a calculation sheet that I have been deprived. He has not taken into consideration the other amounts which was paid to him and the amounts which was deducted to him in due course of his service. Another, my lord, this has been the entire calculation sheet that the petitioner has prepared claiming 14 lakh rupees is on the basis of 1670, which is not correct. It is incorrect. Thereafter, my lord will kindly comes to page number 62, the impugned order.
Yes.
My lord, this is the hearing that was conducted on the basis of the order of this honorable court, my lord. May I read this order?
62.
It
That's
starts
the calculation.
From 63. My lord.
Yes.
In pursuance of the solemn order passed by the Honorable Justice Dr. Chakraborty, High Court, Calcutta, on 8th February 2017, directing the respondent authorities to give the petitioner a fresh opportunity of being heard and pass a reasoned order on the basis of the claim that may be filed by the petitioner. A hearing was conducted by the undersigned on 26 May 2017. The petitioner, Shri Dilip Kumar Mitra, is present. OSD LNP is also present. The petitioner, Shri Dilip Kumar Mitra, submitted his detailed calculation of claim on 2nd March 2017, which has been meticulously examined from our end. After observing the total matter, it appears that as per government order number such and such, dated 23rd June 2000, regarding revision of pay and allowance for the employees of CTC, wherein it was mentioned that the revision of pay will be fixed in the revised scale notionally from 1st January to 1996. It was also mentioned that actual effect will be given from 1st April 1997. This revision of pay and allowance in CTC Limited implemented with effect from September 1st, 2001, and the difference of the same for the period from April 1997 to August 2001 was paid to all employees by installments. My lord, the matters that we continuously do for interest of these installment payments. As per government order number such and such, dated 17 September 2009, regarding revision of pay and allowance of the employees in CTC Limited, wherein it was mentioned that revised pay structure shall come into force notionally from 1st January 2006 with actual effect from 1st April 2008. The revision of pay and allowance was implemented in CTC from September 2009. The difference of pay from April 2008 to February 2009 was paid to all employees by installment. The difference of pay from March 2000 to August 2009, 6 months, is paying to all retired employees as per the scheme approved by this honorable court, Honorable High Court, Calcutta. So the petitioner, Shri Dilip Kumar Mitra, submitted his calculation before the respondents is not correct. The petitioner, Shri Dilip Kumar Mitra, will only be entitled to get difference of revision of pay for the period from February 2009 to August 2009, which will be paid to the petitioner as scheme approved by the Honorable Court, Calcutta, very soon. On the basis of the above, the representation of the petitioner is considered and disposed of. So, my lord, the installments were paid, not that the installments were not paid. I have already shown that all payments were made, my lord. Next, my lord, the petitioner, another erroneous basis of the calculation of the petitioner is that he has calculated actual benefits from the notional dates. That is why he has reached to that amount. Next, my lord, he was only entitled, he has been held entitled to for the revision of pay and allowance from February 2009 to August 2009. And my lord, if I may, my lord, explain in details, that is, when ROPA 1996 was implemented, my lord, it was not implemented upon CTC. It was implemented upon CTC only in the year 2001 by the state government. So from 1996 to 2001, he cannot claim. From 2001 onwards, when it was implemented upon the petition upon the employees of CTC, only from then onwards the respondent corporation will be able to pay. There was a, my lord, there was a scrunch of fund, my lord, and the respondent were dependent on the state. There was rounds of litigation before this honorable court also, where the honorable court, upon considering the financial situation, had directed that you pay the employees upon 5 installments. That was also delayed, and for which we are paying interest. That, my lord, there is a circular also of the corporation, my lord, of 10 July. Under that circular, my lord, every employee has been paid whose right has not been curtailed by this honorable, by orders of this honorable court, my lord. So, my lord, these are the erroneous calculations of the petitioner. Further, my lord,
premise on which the petition has been filed.
yes, I'm grateful, my lord. Further, my lord, there has been a payment to the petitioner, which I have stated in my report that the petitioner has suppressed, rightfully stated so, my lord, because going through the entire petition as well as the report, my lord, there is not even a single word about receiving this payment. If the petitioner can show that the petitioner has, in any of the paragraphs, my lord, pleaded that petitioner has received this amount, my lord, I will rest my case here. The petitioner has not. My lord will kindly comes to my report once. My lord, page 5 of my report.
Yes.
My lord, page 5 of my report, my lord will show the, my lord will see the payment, the evidence of payment, my lord. 19 July 2017, an amount of 41,036 has been paid to the petitioner. My lord, and the proof of payment is at page number 7, my lord, serial number 48. Page number 7, my lord, serial number 48.
The bank statement or what?
Yes, this is the bank statement. Well, serial number 48, Dilip Kumar Mitro, he has received 41036 on the account of payment of difference of gratuity and other arrears. And my lord, this is his bank account number. This he has suppressed willfully. Now, my lord, coming to his reply on this.
Yes.
Now, my lord, may I come to the exception that has been filed by the petitioner, my lord? Coming to the exception that has been filed by the petitioner, my lord will first see that at page number 2, my lord, paragraph number 4. My lord, the petitioner has admitted that there has been rounds of litigations. My lord, rounds of litigation, every time there is an adversary, the petition becomes defective automatically and the petition is withdrawn. This has happened twice before this particular petition, my lord. Further, my lord, the petitioner has not contradicted this. He has only written one single sentence, my lord, at page number 4, paragraph number 8, that there has not been any act of suppression on my behalf as falsely alleged by the respondents. How? That has not been explained. Before that, my lord, at paragraph number 8, he says that he had come to a total of 20 lakhs to be payable, but subsequently upon close scrutiny and necessary adjustment of rupees 98,845, including the amount of 41,000, my total claim has now come up to 14.
41,000 he has admitted.
Well, 40 after I have disclosed it in my report. After that, the petitioner admits.
ঠিক আছে
That shows the conduct of the petitioner, my lord. The petitioner should disclose everything before the honorable court while filing his writ petition, not after once he's
So
been.
what is your submission? Any further?
In my lord, no further submission. My submissions, my lord, I end at that the erroneous calculations has been arrived on wrong premises of considering notional benefits to be actual benefits, and only upon considering the basic pay and not considering the other pays and deduction that the petitioners that the salary slip shows, my lord.
Their lordship, the actual and notional doesn't arise as a question of
Come tomorrow.
That's
Come tomorrow.
Nothing has been paid.
Govindo Chandra Mitra.
Govindo Das Mitra.
Govindo Das Mitra, learned advocate, appears for the petitioner. He has concluded his submissions. Paragraph. Ms. Devlina Chattaraj, learned counsel, appearing for WBTCL.
Yes, my lord.
Has also concluded her submissions. Full stop. Referring to page 17, from the writ petition, she submits that all the payments have duly been made. 17 and 18 submits that all the payments have duly been made to the petitioner in terms of the revision of pay scale. Under ROPA
1996 and 2006, my lord.
1996 and 2006. Full stop. The ROPA in respect of WBTCL was applied since
My lord, 1996 was applied in 2001 and
2001 and
2009.
2009 respectively. কি বললাম? Respectively, by virtue of the policy adopted by the state. And since after such application, the petitioner has received the entire payment to which petitioner was eligible to in accordance with law. Paragraph. Mr. Mitra, learned advocate, appearing for the petitioner, shall make his submissions in reply on the next day. Paragraph. The writ petition shall appear কি heading এ আছে? Motion service tomorrow, that is August 21, 2025. Even if the order is not placed on server, please be there.
Yes, my lord.
এটা রেখে দিন তো। If the division bench is over, division bench collapses, then we will go back and take motions. Appellate side, single bench motion.
My lord.
ভিডিও করে দেবো নাকি? এটি চালিয়ে যাও তো ধর বুঝে তো আমার কথা শুনতে পাবো তো এটা পুরো ফটো তুলে রেখে দাও। করো না।
স্যার আপনার কথা শোনা যাচ্ছে।
হ্যাঁ
হ্যাঁ অডিও ঠিক আছে, শোনা যাচ্ছে কথা।
আমার কথা শোনা যাচ্ছে?
হ্যাঁ হ্যাঁ হ্যাঁ।
হুম? ওটা তাহলে কাজ হচ্ছে? চালু হয়েছে। ভালো লাগছে। কি হলো রে?
হ্যাঁ স্যার।
বলছি ভালোভাবে শোনা যাচ্ছে সেটা জিজ্ঞেস করছে। ঠিক শুনতে পাচ্ছিস তো?
হ্যাঁ হ্যাঁ ক্লিয়ার ক্লিয়ার, কোনো অসুবিধা নেই। আপনি কি এই কন্টেম্পটাতেই আছেন?
না আগে না মেনশন করেছে চলে যাও।
আচ্ছা 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 ঠিক আছে।
করতে যে এইটা ঘুরিয়ে দিলে হয়ে যাবে এইটা। আর শোনা যাবে। শোনা যাবে। আর এটা যখন ঘুরবে তখন ভরমটা এসে যাবে। কত লাইন করে দিলাম যেটা ছিল সেটা। এটা দেখ ফটো এটা অফ করে দেবো। ভরমটা অফ করে দেবো। না না এই যে অফ নেই সব অন আছে দুটোই অন আছে। ছবি পেয়েছে কলকাতায় সাউথ ক্যালকাটার দিকে মেট্রো চলছে না দাস রোড থেকে ওদিকে বাস সার্ভিস টাইমলেস জল ঢুকে গেছে ঠিক একটা ঢুকে হয় না জিপির নামটা কি বললে আমাদের এগেনস্ট আছে
Yes.
My lord, I appear for the alleged contemners.
My lord, may I have lordship's kind leave, my lord?
Mr. Mukherjee. Yes, sir. Yes,
My
sir.
lord, I am in item number 9.
Yes, sir.
9.
Yes, sir.
Running temperature, my lord, and have developed cold, my lord. May I have some time?
Absolutely, sir. You come after vacation?
No.
Because this September, I tell you why, sir. Because this bench will not be available for 15 days in the September.
Then let me wait till after the vacation.
Yes, sir.
I'm sorry, my lord, I have developed fever. I can't speak well.
But don't stress yourself. For this, you should not have mentioned. Your juniors are capable. They are here. Please take rest.
Grateful,
Please take rest. Don't stress yourself.
Grateful for lordship.
You tell us when after vacation?
After
second week of November, from second week of November, sir, you tell us.
No, my lord, your lordship will fix any date.
Normally, 12th 12th of November, sir.
Grateful, lordship, my lord.
All right. So we will, you don't have to worry, your junior is here. When the matter shall be called on, we will pass the order. You
Grateful,
don't have
lordship.
to be there. You be there, sir. You be there. Please, please. Just go and take rest.
I have to, I'm not kidding. Grateful, lordship.
Yes.
Yes. Milord, this is the matter, Milord, you may recall.
Which matter?
This is the
On that NUJ's matter where 4 newspapers.
I am the applicant, Milord. Mr. Dhod is the contender, so I have a right to audience first.
Yes.
Oh, fine.
The direction, yes, the direction.
Let us see the last order.
Minor, kindly have a look.
6th of August 25.
Yes.
Yes. Now they have come up with a proposal of the same. Then how they
that is quoted
over here. Now the only thing is that Milord, I have just received this affidavit, Milord. I will check it up because
what affidavit?
There was a direction.
they have lordship has
led by Mr.
directed.
Well, there was a direction by your lordships. We have to include the.
Wait.
How
Yes.
the order would be complied with, they will come up with a Milord affidavit to that extent. Now they have lordship's desire was there. Initially, there will be a publication of the 4 newspapers, right? And as well as Milord, the in the website of the NUJS and the phone number would be given. So this is, I would say, Milord, the compliances for initiations of the completion of the courses. There are other part as well. What is the other part? Those who have already completed the courses, that they have to scrutinize and issue the certificate. That part has been omitted over here. This, if your lordship kindly take trouble to see, the order of your lordships is at page 4. Last order. Kindly have a look, Milord. Modalities to be followed by the university for completion of the courses. Now, Milord, the certificate will be issued to the enrolled candidate who have already completed their respective courses.
Page?
This is page, internal page 4. This is page 7 actually. If your lordship's order, page 4. Have your lordship got it, Milord? Yes. Now, certificate will be issued to the enrolled candidate who have already completed their respective course. Now, pause here for a moment. Lordship, kindly take trouble to see their affidavit in opposition of the paragraph 5. They have.
Where is the affidavit?
They have filed it.
Previously?
Yes, it is in the record. Page number 3 onwards.
What is the? Tell us first.
They have stated that they do not. Initially, Milord, the
affidavit is a prior one prior to this order?
Prior to this order.
So after this order, they will follow this order.
I tell your lordship what is the difficulty. If your lordship takes the Milord, the order in the contempt, order in the contempt is absolutely and abundantly clear that they have to follow 3 things. The student who have enrolled prior to a cutoff date, they have to check the same, issue the certificate and completion of the courses, and thereafter the certificate. Here, Milord, a class of the peoples are there. They have already completed their courses. That certificate has not been issued so far, not a single one. So what I'm proposing today, they have come up with a very good suggestion. I am appreciating that. At least they have checked. We have followed the entire procedures. We have given the data, whatever they have or they have not, by way of a Google Forms. Now they checked up and they come up by saying these peoples have completed their course and therefore we are issuing the certificate. There will be the proper compliances of the order. Otherwise, this I would say the initiations of the Milord compliances of the order. It will be not be full compliances of the order.
Kindly see.
My lord.
Modalities to be followed.
Correct.
Kindly see.
No, that's the order.
Certificate will be issued to the enrolled candidate.
Correct.
Who have already completed their respective courses.
Correct.
So you are agreeable to this?
I am agreeable to that extent because they have stated on their affidavit that they didn't had any debtors with them, right? That is on record in the paragraph number 5 of their affidavit. So they have come up by saying that you give us the data, we will check the same, and thereafter there will be a full compliances. That is what I'm on today. And also they have
data are provided by you.
I have already provided.
Very well.
So
they will issue the certificate.
Therefore, at least one certificate is to be issued. If your lordship kindly take trouble to see the order in the contempt, it clearly speaks of the 3 part. Issuance of the certificate.
So they will issue.
Millet will be issued is Millet. I understand because this matter lordship knows since 2017 peoples are fighting this case. There has to be a Millet proper guideline and the time frame. What are your grievances now? No, grievances is that if your lordship kindly take trouble to see the order in the contempt, kindly take trouble.
We admit that.
I am saying.
What are you saying?
I am simply saying that kindly adjourn the matter. In the meantime, let them consider the forms and scrutinize the same and apprise this court that these peoples have completed their course. So therefore, we are issuing the certificate, and these people, those who have approached, have not completed their course. We are taking the initiative for completion of the course.
You have submitted all the data, or
I have submitted.
Very
That is what I am saying.
you want adjournment.
Yes.
This is factually not correct. There are 2 things.
No,
Today,
Mr. Dhar.
Yes.
What I have understood, let me explain. So far as those who have completed the course, they are yet to be issued with the certificate.
Correct.
Correct.
Yes.
Issue the certificate and file a short affidavit that we have issued on next week.
May I make my response? May I make my response? Well, this matter was taken up on 6th of August. Now, after hearing both sides and after recording the consent of the proposer, Lordship passed an order. Once your Lordship passed an order, this is a watertight thing. We cannot
Mr. Dhar, please don't remind us that we are after all in contempt jurisdiction.
Yes.
If ultimately the spirit and order of the original order is not carried out,
yes,
then we will be bound to follow the law of contempt.
Absolutely.
So don't try to wriggle it out.
No, I'm not trying to wriggle it out.
No, Mr. Dhar, Mr. Dhar, the submission just now you have met is not at all accepted to us.
Why it is not
You
accepted?
tell us a date. We are keeping on that date. You file a short affidavit.
I have no difficulty. But my learned friend is trying to have a shortcut. May I say I have no difficulty? Why should I be standing in the way, my lord?
So do that and come back.
No, may I
come back?
May I just say, my lord?
Yes.
Lordships have passed an order recording that there are 2 categories. Ones who have completed.
Where is the difficulty, Mr. Dhar, in issuing certificate, those who have completed the course?
I have to know who are the persons. I have to get the evidence of all those. They have not given this.
1 second. Yes. So you make that submission?
Yes.
Don't start your submission that it's a watertight order now. Nobody, but the order is on consent. Don't say all these things.
No, I say that.
You simply come up, you are representing the alleged contender.
Yes.
You simply come before this court and say that we will comply. These are the difficulties. Solve the issue. We shall comply. Let us solve.
May I say these parts are already over. The difficulty part was sorted by your lordship.
Mr. Dhar, you are saying that those who have completed the course, you don't have the particulars.
No, that is the. May I complete, my lord? May I complete? Lordship will understand. Lordships. This was the situations was prior to lordship's intervention. when I expressed that these are the difficulties, I don't have from 2012 who have completed, it could be ABCD, anybody may come. Then Lordships, after seeing the proposals, specifically decided what are the documents which have to be given to me. And those have to be circulated to 4 newspapers and 1 in all India, 42 cities. We have done so. That was done on 14th of this month. So now today my learned friend is trying to say that he has already given something before that. In that context, I say this is watertight.
I will direct them to file by next week.
My lord, that directions is already there by your lordships. They have to provide the documents as per, yes, kindly see, my lord.
Show us.
Yes, kindly take, my lord, lordships order dated 6/8/25.
Yes.
Madam, may I place it? The last order dated 20 July 25 speaks for itself. A suggested modalities for compliance of the order of the coordinate bench dated such and such is made over to the court today. Copies have already been provided to Mr. Kollan Bandobadhyay, learned senior advocate appearing through virtual mode for petitioners, and also to Mr. Shuman Sengupta. Thereafter, Mr. Pratik, the senior advocate appearing for the alleged contempt, has placed the said suggested modalities before the court in its entirety. The modalities suggested are reproduced herein below in its entirety. Thereafter, Lordship has reproduced entirety. Now, Lordship is kindly see the direction. Page number 3. The above online informations along with the proof of document. Kindly mark this proof of the document. It has to be post this advertisement, not pre. Proof of document should reach the university within 6 weeks from the date of publications of the notice. After the said date, no application will be entertained. This part my learned friend wants to be diluted. Now, second, modalities to be followed by the university. Kindly see, Mala, there are one is certificate will be issued to the enrolled candidates who have already completed their respective courses. This is that my learned friend wants dilution. Now 2, 3, 4, 5, I'm not reading it. All have been taken care of by your lordships. Thereafter, page number 4, the West Bengal National University of Juridical Sciences, such as a notice. This has, what should be the notice? Lordship has given clearly. Then out of the said suggested modalities, the first 3 pages shall feature in the official website of the university. Only that was done. And 4th page, being the last page, will be the advertisement to the public at large, which shall be published in the official website of the university in 4 newspapers. My lord, so far as 8 Times of India, we have done so, 42 cities, all India. Telegraph done, Anandabazar done, Shanmark done. The modalities quoted above for compliance with the direction dated 13 June have been read over in the open court, and the same has been accepted and agreed upon by the learned counsel appearing for the petitioners. Now, in this context, I say, whatever the university and the respective parties would be doing as per this modalities.
Correct.
Now, today, if learned friend wants that I had already given document and therefore give me a certificate, then there would be a violation of these modalities.
I'm not saying so.
He's not saying so.
Let him.
Pursuant to the advertisement, your clients, whoever.
Yes.
Who comes under English 1, under page 3, come on. See, modalities to be followed.
Modalities to be followed. Yes, my lord.
See.
Yes.
Serial number 1.
Serial number 1 certificate will be issued to the enrolled. Yes.
So following these modalities, those candidates who want the certificates now, because they have completed, have they also submitted their materials in terms of these modalities?
My lord, yes.
After the advertisement?
After that.
After, I don't know, my lord, this part. After they have submitted.
Not properly instructed. I can show here.
Maintenance, do that.
If they do, definitely it would be given. There is.
Then where is the problem?
They have to scrutinize the same.
Of course.
Yes, I am agreeable to that extent.
So why you are
There are 6 weeks after advertisement.
Yes.
6 weeks after the advertisement, they have to
6 weeks to outer limit.
No. Yes, that is outer limit, not below.
Right.
The first thing is that I have given. Now, Millard, the premier university.
You are agitated today. Let them do their work.
Millard, kindly appreciate one aspect. The direction was very clear. First,
those who have enrolled prior to 2017 are entitled to get the certificate. Those who have kindly.
We are in favor of giving certificates.
Correct, Millard. I am bow down to your lordship, Millard.
So this clause 1,
Yes.
following the modality,
Yes.
the candidates who are covered under clause English 1,
My lord.
they have already submitted.
I have submitted. Yes.
They have submitted.
Correct.
There may be 100, there may be 400.
Maybe one.
Maybe one. Submitted.
Correct.
So wait.
I am waiting. I am waiting over here.
Simply we are adjourning to.
Yes, that's it. That's it.
এই তো কথা।
এই তো।
All right. All right. So suggest a date.
But as per your lordship's
both of you suggest a date, preferably Wednesday, after third week of November.
As your lordship fix it upon the 12th November.
12th is not third week.
Third weeks.
Let them also have some time.
17th or 18th?
Yes, Mr.
17th, yes. Yes, absolutely fine.
Wednesday.
Mr. Sengupta need not take much stress on it. If anybody fulfills all the criteria, definitely he would be getting the certificates.
The only apprehension is that I am facing Mr. Dhar.
Acha. Do you file any affidavit of service?
Yes.
Showing that
Yes. Well, it has been. Today it has been affirmed.
এগুলো কি আছে? What are
this contains, my lord, all the newspaper photocopies of the 4 newspaper publications.
Mr. Pratik Dhar, Learned Senior Counsel, appearing for the alleged container number 1 and 2, submits that pursuant to the direction of this court dated August 6, 2025, the necessary advertisements have already been published in the 4 newspapers mentioned in the order. Full stop. He files affidavits of service.
Compliance. Compliance of
affidavits of compliance. Kota ekta?
4.
Acha, 4 numbers of affidavits of compliance.
4 matters in 4 contempt matters.
To show that the necessary publication has already been caused in the 4 newspapers. Full stop. These affidavits are taken on record. Full stop. Mr. Dhar further submits paragraph that following the modalities and the direction of the court dated August 6, 2025, steps have already been taken.
Yes.
And steps are being proceeded with.
Yes.
With right earnest.
Yes.
With right earnest for complying the direction of the coordinate bench. Paragraph. On the joint prayer of the parties. আচ্ছা মাথার উপর লিখে দেবেন মিস্টার সুমন সেনগুপ্ত লার্নেড অ্যাডভোকেট ওই অ্যাপিয়ারেন্সটা না দিদি ওইটা দেখে মেরে দেবেন লিখে দেবেন On the joint prayer of the parties, the matter shall appear under the heading কিসে আছে?
Assigned matter, contempt. Assigned matter.
All these applications shall appear under the heading contempt application bracket assigned
on 17th November.
17th is Monday, not possible. 19th.
Yes, 19th.
November 19, 2025.
Well, would it be lordship's pleasure to direct us to use an affidavit by putting on the record that we have also filled up the data and provided to the university in the due times?
Mr. Shumon Sengupta, Learned Counsel for the petitioners, submit that the candidates have already submitted the relevant information, data and records with the university following the modalities recorded in the order dated August 6, 2020. 5. He shall file an affidavit in support of his contentions, disclosing the relevant documents on the next day.
My lord, if my learned friend can give me an advance copy, I can expedite for his clients if they have completed so that they can get
An
the
advance
certificate.
copy shall be served upon the learned advocate on record for the alleged contenders.
Obliged.
Deeply obliged.
Thank you.
My lord, same order up to 4.
Yes, the only one order in all matters.
Yes.
Thank you.
Yes.
My lord, my lord, I am for the petition and my lord led by Mr. Shakosin, my lord. My lord, pursuant to the my lord, order, parent order 1/8/2022, the hearing has already been given, my lord, on 25th August. So let the hearing be held and
let the
hearing has already been given 25th August in terms of the order 1/8/2022.
So we are adjourning.
Well, we have annexed it to a affidavit, your lordship. May keep it on record. We have annexed the
compliance, basically.
Compliance.
Compliance. Your lordship will find the notice my learned friend is referring to at page 16 of the affidavit.
Order has also been passed.
No, my lord, the hearing is scheduled on 25th of August.
Oh. What's your name?
Taposh Maiti.
Mr. Taposh Maiti. Led by.
I'm sorry, I was
Let me
so crowded, my lord, I was outside.
All his clients. We are having to request his clients to come in.
Mr. Shakoshen, learned senior advocate, with Mr. Taposh Maiti, learned advocate, appears for the petitioner. Paragraph. Mr. Shishanno Bandyopadhyay, learned senior standing counsel for the state, has submitted an affidavit of compliance affirmed on August 18, 2025. The same is taken on record.
It is not an affidavit of compliance.
It is named so.
But they have
very well an affidavit. Cholo, compliance ko thoda baad din. Affidavit affirmed on such and such, the same is taken on record. Full stop. The affidavit shows that pursuant to the direction of the court, a hearing is scheduled to be held on August 25, 2025. Full stop. Paragraph. In view of the above, the proceeding stands adjourned.
Yes, your lordship will keep it after anything.
After
Proceeding
vacation.
stands adjourned.
But
Full
kindly
stop.
keep it after the vacation.
The matter shall appear under the heading kishe ache? Contempt application bracket assigned on কবে দিলাম?
19th.
November 19,
One line,
2025.
One line that the your lordship expects that the hearing will be concluded and order will be communicated to the parties in the meantime.
What purpose they are doing so, Mr. Sen? Then
one line will satisfy.
Yeah.
No. Court cannot satisfy everyone.
No, at least, my lord, the hearing has to be
you are
given.
satisfied?
Mr. Sen may assure so on my saying because I have advised my client.
Otherwise, why the hearing will be arranged? The moment I am recording, hearing is scheduled unless they give hearing and conclude it and serve the impugned or whatever. The reasoned order, where is the utility?
19th of November. Wait.
9 November একটু আমাদের ক্যালেন্ডারে দেখো আমি আছি তো ওখানে একটা বড় সময় নেই আমি টাইম
In item number 9, I beg to appear on behalf of the contemners. Six, I'm sorry. Item number 6.
Yes, sorry.
I beg to appear on behalf of the millet contemners.
We are for the manner.
Alleged contemners. In the last occasion, I have pointed out, if your lordship kindly take trouble to see my affidavit once more, in page 7,
In page 7 of the compliances,
Page 7.
in table number, the lordship, see there is a different table numbers are there. 1, 2, 3. Kindly. Oh, sorry. The different table numbers are given.
Table number,
Roll number.
page 7.
Page 7. This one.
Yes.
Yes. The kindly take trouble to see the serial number 11.
12.
11.
20,000 per quarter.
Yes, that is to be enhanced 25,000. Millet, we have taken the initiative. Millet, it has been sent to the Millet Amanda for the waiting. Lordship keeps it up on the 19th. In between this time, I believe the Millet, the entire hurdle would be covered. No, 19th রাখা হোক তারপর যা হবে দেখা যাবে।
কি হবে তাই? আপনার রিপোর্টটা কি
কিছু দিন আমি স্যার আমরা ওয়েটিং করে আসছি।
কবে 19?
হ্যাঁ
19?
Sorry?
19 না, ভ্যাকেশন করে 19th এ রাখতে বলছেন।
ও রাইট।
তার মধ্যে উনি পেমেন্ট করে দেবেন।
আমাদের তো টাকাটা চেয়েছি, টাকাটা
Mr. Bhudev Bhattacharya, learned senior advocate, appears for the petitioner with MS Sohini Bhattacharya, learned advocate. Mr. Shuman Sengupta, learned senior government advocate, appearing for the alleged contemner. One.
কত রে এটা?
Kota?
Contemners 3. There are three contemners.
Contemners.
With Mr. Shambhuddha.
With Mr. Shambhuddha Datta and Mr. Sanatan Paja,
একদম
learned advocates, appearing for the alleged contemners, submit that they have already taken steps and the authority is in session of the issue for enhancement of land
for full compliances of the order.
For compliance of the order of the coordinate bench, out of which the contempt arose. He further submits, comma, in his usual fairness, comma, that if some time may be given, the total compliance may be there.
Obliged to lordship.
Paragraph, accordingly, the matter shall appear under the heading
Assigned contempt.
Contempt within bracket, contempt application bracket assigned on ওই একই দিনে দিয়ে দিন। কবে দিলাম?
19th.
19.
Deeply obliged.
19 November, sir.
Deeply obliged, my lord.
After vacation.
Yes, sir. Now you go and enjoy the vacation. Go and enjoy the vacation.
To go.
Why not?
Why to go?
Wherever you want.
একবার কাশ্মীরটা ঘুরে আসুন স্যার।
Why to go? My home is my only place to reside. I am not alone.
Take care of yourself.
The person who was taking care of me, he will be out of town.
Don't leave them.
Out of town. Because
order করে দিন injunction.
I am now 85, 86. I will
86 is no age.
No age.
One of my relatives, she is a German. She is German. She is now 87. 3 days back, I've seen her video. She was gymming.
My lord, those are exceptional fact, my lord. But in our family, our great grandfather died at the age of 50. Then the forefather at the age of 45. My own grandfather died at the age of 65.
So, don't worry.
My father died at the age of 68, 69. I am
a young man of 85.
Young man?
Yes. Expecting a century, sir.
Young man I am.
Take care, sir. Take care of your health.
Thank you for your day.
Thank you, sir.
My lord, kindly take page 10 of the contempt application and the order of.
না না আগে কি বলছে পেজ 10 দেখি।
Lord, kindly see the order. Kindly see the operative portion of the order.
Let us first search it out. এত কাগজ।
Your lordship takes up the compliance report, there the order is there annexed.
Compliance report.
Yes, on the last occasion order I have submitted
It is there, the contempt petition is also my lord, quite thin. The only annexure is the order. My lord, this is an order of 6th July 2022.
Now, wait. Compliance report কোথায় ফেলে দিয়েছেন?
on the last statement we had submitted.
Let's see.
হ্যাঁ ওইটাই ঢুকে গেছে।
Lord, I would beseech your lordship, at the first page of the order, there is a previous order of a division bench which has been quoted. So, my lord, this quoted portion, if your lordship see, there is an operative portion of the quoted portion in internal page 2 of the order. My lord, kindly take about 3 lines from the top. There's a sentence starting with therefore.
One second. Division bench of this court, considering this appeal at an earlier point of time on 4th such and such, made the following observation.
Correct.
The issues pertinent to the question whether in fact therefore.
Yes, we are of the opinion that the respondent state has to place on record an affidavit detailing the reason for setting aside the earlier selection on the ground of deficits in the viva voce, and also place on record the relevant resolution and the documents pertaining to the meeting of the concerned authority. Then, my lord, a selection process of recruitment of Anganwadi workers started in 2010. It is not exactly clear to what extent the exercise proceeded. Admittedly, they had reached the viva voce stage. Then Mr. Mukherjee's submission is recorded. Then, my lord, kindly take the last para, internal page 2. The earlier division bench specifically remarked, it is not possible that a candidate who was successful in the earlier process of selection is denied the opportunity of being appointed, though there was no violation of any norms and guidelines of selection process. A person who has participated in the selection process is entitled to know its result. If the selection process was proceeded to preparation of a panel, the life of the selection process has to come to an end. There was no irregularity in the conduct of the selection process. There are vacancies which has not been filled up, and the empaneled candidates remain eligible to be appointed. There is no reason why the empaneled candidates should be deprived of work opportunity. On the other hand, it is found that the selection process was conducted in a irregular way has been conducted in a regular way, but no panel was prepared. Then there were so many years. It is a fit case where the selection process should be undertaken by the authority. In any case, somebody has to take a decision on the issue. We do not think that the impugned order passed by the learned single judge would help to resolve this issue once for there. In those circumstances, we direct the Secretary, Department of Women and Child Development and Social Welfare, Government of West Bengal, to consider all the facts of this case and the observations made by us and by the previous division bench, and come to a reasoned decision with regard to the above selection within a period of 8 weeks. So, my lord, there was two conditions. A, they had to consider all facts of this case and the observation made by both the division benches, which included the observation made in this order and the previous order of the previous division bench. Now, my lord, kindly see the compliance report and what is being sought to be done in alleged compliance of this order.
But has the reasoned order been passed?
Nothing. Lordship kindly looks at if this is the reasoned order, Lord, then the question, my lord, the meaning of reason has to be altered in Black's dictionary or normal dictionary.
See the reasoned order.
My lord, kindly have a look at the compliance report and kindly take the trouble of coming to page 12. My lord, two observations. Observation of this order of 2022 and the previous order of the division bench. They had to be taken into consideration. Page 12.
Yes, Mr. Bose, we are on 12.
My lord, first paragraph is utterly irrelevant. Now, my lord, kindly have a look at paragraph 2. That the then project selection committee, in its resolution of 2012, had stated that tabulation of marks and ranking of the candidates had not been drawn up and appointment letters had not been issued. The said committee had resolved to arrange for re-interview for willing candidates who had applied for the post of AWH pursuant to the notification of 2010. That the project level selection committee is no more in existence at present. The said committee has been done away with and replaced by a district level selection committee, which is entrusted with conducting selection tests for engagement of AWH in all ICDS projects run by the state within the district, such and such, has stopped. Then DLSC has come into existence by a memo of 2012, modifying the memorandum of 2006. That the eligibility criteria of Anganwadi helpers and the scheme of examination, as was prescribed at the material point of time in memorandum of 2006, has also been changed by way of memorandum of such and such. Considering all facts and circumstances, it is concluded that the process of engagement of such and such, which was initiated by notice of such and such, should be cancelled, and fresh engagement process of Anganwadi welfare project may be undertaken. And my lord, kindly come now, my lord, apropos this, my lord, kindly come to the division bench order. So, my lord, they have rendered the entire, both the division bench orders nugatory. Well, lord, two observations. The first observation, if your lordship will see, internal page 2 on the towards the top, 3 lines from the top. Therefore, we are of the opinion that the respondent state has to place on record an affidavit detailing reasons for setting aside the earlier selection. So this was the stand taken by them then. So otherwise the order would be rendered nugatory. Now, my lord, kindly see, on the ground of deficit in viva voce and place on record the relevant resolution. So this was placed. Now, when the final order is being passed, my lord, kindly take internal page 2 towards the bottom, where once again the observations of the previous division bench apart from this is recorded. It is not possible that a candidate who was successful in the earlier process of selection is denied the opportunity of being appointed, though there has been no violation of any norms and guidelines of the selection process. Then, my lord, then the observation is there. In any case, somebody has to take the decision. Then they say that the operative portion directed the secretary to consider all the facts and the observation made in the previous division bench and come to a reasoned decision. What they have done is, what was there earlier, what was placed when the order was passed, they have just reiterated the same thing. What happened to those candidates? What happened to the process? There was no irregularity in the process. That's been the specific observation of the division bench. So then my respectful submission, my lord, in letter and spirit and, my lord, the effective operative portion of the order has not been complied with at all. Well, where we started in the before the division bench when the appeal was filed, my lord, we've gone back to square one. Because based on the reasons, there is no reason whatsoever. What they were required to consider, apart from considering that, they have considered things which are utterly irrelevant, and that was already there before the division bench. Because this order, if your lordship see, it was passed in the year 2022. And they are referring to cancellation made in the year 2012. But the DLSC came into existence in 2012. So this fact was well within the, while deciding the appeal, well, it was before the division bench. So considering this, the division bench passes the order, saying if there has been no irregularity in the process, the candidates were successful, how do you deny them appointment? So that is what was required to be considered by them. Well, now they put, but everything has gone back to square one. Now they are saying that since it has been cancelled, it has to start afresh. So, well, the situation is where we were before we filed the appeal. So the appeal court order effectively has not been complied with. So there, in my respectful submission, there is gross violation of the order. So basically, this is another way of, my lord, circumventing the order of the division bench. And, my lord, as your lordship is aware, my lord, Subroto Roy's case, Supreme Court says circumvention of an order itself is an act of contempt. And in fact, my lord, the compliance report is nothing but an aggravated act of contempt, because they were required to indicate how they have complied with the order. And they have come up with this order. Well, if your lordship will see the order, which was passed in 2024. In any way, my lord, 8-week compliance is not there. The order is of 2022. On both accounts, my lord, there is gross violation.
Yes. What is your submission?
According to the records that are before that were relied upon and considered, that has already been with your lordship through this record.
Sir, you are answering the charge of contempt. Keep that in mind, and then you answer with your, if you have any legal answer, including your legal answer.
Your lordship will give me a day's time. Your lordship will kindly enter this for today. I thought it's so they wanted to have a exception to that. I thought this would be over.
You
That's all.
You violate order of a division bench, not one, two. You are in contempt. And, Melo, interestingly,
if they don't come up with your exception, he has not come up.
According to us, Lord.
So you proceed as if they have accepted your contention on affidavit, they have not denied. Now you defend your charge, the charges against you.
No, exception service order. Exceptions, we've taken out the exception.
You have filed?
Yes, sir. It's here. Allow us to file the exception.
Copy.
Copy down. What we've said is that there has been non-compliance.
No,
this is not
they
in
have to
compliance.
comply. They have to consider and come back. If you rely upon it, then they have to consider and come back.
were told that they'll be filing.
I don't mind in allowing you to file it, but if you file it, you have served just now, they have to consider and come back.
No, my lord, your lordship need not consider the exception.
So don't
My
take
lord,
it back.
contempt.
Take it
Yes,
back.
yes, my lord. Kindly give it back.
Sure.
Yeah, Virothi.
Yes, you argue.
My lord's order dated, my lord, 22nd of the year 2022, 6th of July, that where your lordships had reiterated that portion. Your lordship has, my lord, in the internal page 3, your lordship has also, my lord, stated, a person who has participated in a selection process is entitled to know the result. If the selection process has proceeded to preparation of a panel, the life of the selection panel has to come to an end. There is no irregularity in the conduct of the selection process. There were vacancies which have not been filled up, and the empaneled candidates remain eligible to be appointed. There is no reason why the empaneled candidate should be deprived of work opportunity. On the other hand, if it is found that the selection process was conducted in an irregular way, or it may have been conducted in a regular way, but no panel was prepared, then after so many years, there is a fixed case why a new selection process should be undertaken by the authorities. So, my lord, exactly that is the infirmities that were there at the relevant point of time. But that has been considered, and there's no other option than to have a new selection process to that effect. But seeing that there are infirmities, there has been irregularities, so, my lord, subject to my lord's kind consideration, what would have been the other way around?
That you have to say.
That is the thing. That is the reason, my lord. This particular order, according to me, my lord, this particular order, my lord, we have complied with your lordship's orders, my lord, and the relevant records has been relied upon, and that has been taken care of. From these records, the following facts are revealed: that as per point number 3D of the memorandum of 25/1/2006, in absence of any MLA, chairman, Chabadipati of the Panchayat Samiti concerned, or in his absence of BDO, will be the chairman of the selection committee. However, from the attendance sheet of selection board of the dates of interview, it is not clear who had chaired the said board in the days of interviews. There are no such minutes of the meeting from which it can be ascertained who presided over. These deviations which happened during the process of IVOC test are in violation of the norms as prescribed in the memorandum dated 2006. Second one, that the then project level selection committee PLC in its resolution dated 25/4/2012 had stated that a tabulation of marks and the ranking of the candidates have not been drawn up, and the appointment letters had not been issued. The said selection had resolved to arrange for re-interview of the willing candidates who applied for the post of AWHS pursuant to the notification dated 2010, that the project selection committee level is no more in existence at present. The committee has done away with and replaced by the district level committee, which is entrusted with the conducting selection tests for engagement of AWW and AWHS in all ICDS projects run by the state government within the district. The DLSC, that is the district level committee, has come into existence in 2012, modifying that earlier memorandum of 2006. The eligibility criteria of the Anganwadi helpers and the scheme of examination as prescribed at the material point of time has also been by way of a change in the memorandum of the department. Considering as stated, it is concluded that the process of engagement of Anganwadi helpers in Mathurapur 1 ICDS project South 24 Parganas, which was initiated by notice dated such and such, should be cancelled and a fresh engagement process of Anganwadi workers ICDS may be undertaken. But that's the only way that this infirmities can be removed and the problem can be resolved.
That is your submission.
Except otherwise,
You are submitting that you have complied with the direction of the division bench.
because seeing the and noting the infirmities, the adjudicating authority, it cannot keep that thing rolling over and over again. At best, if they are aggrieved, they can have a fresh cause of action for that.
Yes.
My lord, kindly issue a rule, my lord.
Secretary has taken the order.
My lord.
Principal Secretary has passed the order.
Yes.
So you are saying that this is the stage which is prior to the filing of the all writ petitions and like that.
Yes. Well, if your lordship will see, we direct the Secretary, Department of Women and Child Development and Social Welfare, he was the authority. This has
Mr. Bose.
Yes, my lord.
We are taking a contempt proceeding.
My lord.
The assessment of the order,
My lord.
on its merit,
My lord.
the quality of the order,
My lord.
can we look at it in the contempt?
No. So that's why I said, my lord, there were two conditions, there were two directions there.
Absolutely.
My lord.
Now, the way he has understood these directions,
My lord.
he has done this.
My lord.
Correct?
Yes.
The order may be grossly wrong.
Right.
Order may be grossly illegal. But in a contempt proceeding, we have in these facts, a very limited authority.
Correct.
Right?
My lord.
We cannot assess the correctness or the quality of the order. Correct?
Absolutely abide.
The way he has understood it.
No, that's what I'm saying. It's not a question of understanding. If today your lordship passes an order, say that you do A and B. So the authority does something, not A and B, but he does C and D. Well, can the contemptor then come and say that I understood A and B to be B, C and D?
No, I tell you.
Well, I'll tell your lordship, well, there is no ambiguity in the order. If your lordship looks at the directions,
absolutely
he was supposed to pass reasoned order after, well, on the basis of the observations made, consider all the facts. This is one.
And it is, Mr. Bose, the moment it is contempt.
Observations made by us and the previous division bench. If he had said anywhere that this is my understanding of the division bench's order, and this is my understanding of the previous division.
Yes, of course.
There is no reference, remote reference in the.
It is the reflection of mind. He might have understood the direction totally in a wrong manner.
Well, this kind of reflection will
be. He might have applied it absolutely in a wrong manner.
Right.
But sitting in a contempt jurisdiction.
But he has to apply.
Yes.
He may have applied it wrongly, rightly. I'll challenge it.
Exactly.
No, but he did not. That's what I'm trying to tell you, Lordship. The contempt is, if your Lordship looks at the direction was specific.
Absolutely.
Now, if there is a specific direction, you could have considered it and decided in whichever way the authority thought fit and proper.
Correct.
Permissible.
But the moment it is contempt,
yes,
question of mens rea comes.
Well, that is why I am looking
quasi-criminal.
Absolutely, my lord.
So while adjudicating a contempt proceedings,
my lord,
the court has to see what is the mens rea involved. Direct violation, a willful or deliberate violation, or wrong understanding.
Well, I say here, this is an attempt to circumvent the direction. No, my lord, complete circumvent. I'll tell your lordship why. Because if your lordship sees,
this is not circumvent.
No, my lord, kindly have a look at this. This says to consider all facts of this case. The moment division bench said all facts of this case is the fact recorded in the orders, which is the selection. There was nothing irregular in the selection process. There was no deficit in the viva voce. Despite that, the selected candidates were not given appointment. Why? Somebody had to decide it. So the authority was directed to decide it. And my lord, while passing this direction, an additional direction was given to consider the observations made by us, the present division bench, and by the previous bench, and to come to. So, my lord, otherwise this operative directive part of the order will become rendering Oshio.
No. I tell you.
Apropos this, your lordship looks at the reasoned order. Apropos this, what he does not consider anything on the basis of which he was directed to consider. What he has done is mechanically, he refers to a memo of 2012.
Agreed.
And then comes to a conclusion.
Agreed.
That itself is non-violent. That's complete violation of the order itself.
Because the moment we will be adjudicating a contempt, we have to bear in mind what is the punishment. Ultimate punishment is imprisonment.
Yes, of course.
So, to go for an imprisonment where the proceeding ends with an imprisonment.
Yes.
The court must see the mens rea as well. It's a quasi-criminal proceeding.
Correct.
Now, the moment I see the mens rea, we see the mens rea.
Yes.
We have to see. The order may be absolutely bad order.
Correct.
It is absolutely in conflict with the direction of the division bench. Maybe.
So that's a deliberate violation itself.
No.
Here, my lord.
Willful and deliberate violation is not same as that of the misunderstanding or wrong understanding or misconstruction.
Allow me to address your lordship with that. If the attempt by the authority is to deliberately circumvent the directions, and in order to camouflage to say that so that I don't suffer the contempt, because he knows inevitable non-compliance, the consequence is contempt. So if the attempt is to protect himself, him or herself from the act of contempt, what he does, all he has to do is just do without complying with the direction, pass something which otherwise would become a deliberate violation.
No.
So, my lord, if your lordship looks at it, otherwise, my lord, no authority in this country will ever comply with any direction.
No.
Well, today, if your lordship says, if your lordship gives a blanket order, consider the representation in accordance with law, I would have understood. But this is not the purport of the order.
Absolutely.
The purport of the order is much more than that.
Absolutely. But
so then,
I expected these answers from the alleged contemners, but it did not come.
Yes.
But while we are dealing with this, we have to keep it in mind. What is the ultimate punishment, Mr. Bose?
But if
if we proceed by holding contempt, the ultimate punishment will be imprisonment.
Consequence.
Absolutely.
Well, in this country, apart from the judicial system, nothing effectively, the entire the executive, is functioning today because of the judiciary.
Totally.
So, my lord, if today, now, my lord, if your lordship will see when the contempt application has been filed, my lord, in order to, my lord, just to address this query of your lordship, kindly see the contempt application was filed on February 2023. And when was the order passed? 8 weeks was the period, and the order was passed in 2024. So, basically, nothing but an attempt to circumvent the order. So, my lord, how could he have passed the order?
Adjudicating a contempt, the court will have to be little slow also.
Well, it cannot, slow, well, is one way of looking at it, but it cannot, when there is a deliberate, willful, contumacious violation of an order on the face. Well, 22 order, I filed contempt in 23, direction was 8 weeks. You pass an order in 24. Why? Just to save yourself from the act of contempt. Writ large on the face of it. Your lordship looks at it.
But
absolutely writ large on the face of it. I'll give your lordship 2 judgments.
Yes, bring those.
Those two judgments of the Supreme Court, where Supreme Court, one is Sahara and
Sahara, the facts was different.
No, I am not on that.
Different. Why?
I am on
circumvention.
Yes.
Circumvention in Sahara was totally factually different.
Of course, it would be factually different, but it cannot be factually the same. But
here the mens rea, we do not find
is
such that there is a deliberate and willful violation.
Very well, my lord. If your lordship is on mens rea, allow me to bring the new judgment of Justice Pardiwala, where my lord, there is two judgments recently. One is Justice Pardiwala and the other judgment as a, if my lord, possibly of Justice Bela Trivedi on contempt jurisdiction.
Yes, bring.
Very well, I'll
Bring.
Any day, your
Bring
lordship.
those.
Very well.
After vacation. Because I will not be there. I will be in circuit. Ashu.
Okay. May I take your lordship's kind leave, my
Oh,
lord?
yes.
So then in that event, my lord, can we file the exceptions?
Absolutely. No issues.
Kindly
Give
take
me
the
a
exceptions
copy.
on record. I'll give
Take
them.
your copy. On the prayer of Mr. Moinak Bosch, learned senior counsel appearing for the petitioner, time to file exception in the form of affidavit stands extended till today. Full stop. The exception filed in court today is taken on record. Full stop. Copy has been served upon Mr. Shubhobroto Das, learned advocate appearing for the alleged contemners. How many?
One.
Alleged contemner. Paragraph. Upon hearing the submissions of Mr. Bose and Mr. Bose no, Mr. Moinak Bosch, learned senior advocate, has made his submissions and he shall continue on the next day. Full stop. He submits that some time may be given so that on the point of law, with regard to the jurisdiction of a contempt court, he shall bring some judgments on the next day. Paragraph. Accordingly, the matter shall appear under the heading কিসে আছে? Assigned. Contempt application. আচ্ছা এটা কি করে আমাদের ঘরে contempt application হয়? হ্যাঁ তাহলে তো সেটা অ্যাসাইন হবে।
সবই অ্যাসাইন।
হ্যাঁ অ্যাসাইন না হলে হবে কি করে? Contempt application within bracket assigned. অ্যাসাইন দিতে হবে তা নাহলে আমি আসবো কোত্থেকে? হ্যাঁ আমি নাহলে আসবো কি? নাহলে আমি আসবো কি করে এখানে? তো আমি দিতে পারি না। Assigned under the heading contempt application bracket assigned on কবে বলেছি আগেরটা?
19 November 19th perhaps.
November 19, 2025. Sure.
On the last occasion, your lordship has pleased to pass an order. Particular order.
এইটাই তো পয়েন্ট, এটাই তো লিগাল ইস্যু। আমি এর জন্য ইন্ডিকেটও করলাম। একটা আর কি আছে?
Your lordship, kindly see the order dated 6th August passed by your lordship. Page 2.
Yes.
Now, Dr. Patra is to take instruction in the meantime from the alleged contemner number 2 and make submission on the next day regarding carry out new order. What is the carrying out? If your lordship kindly come
Give
to
appointment.
No, first of all, your lordship kindly see the affidavit of the board. The sole contemner at that time. The affidavit in opposition filed by Mrs. Bhattacharjee.
Now, Dr. Patra, what is your instruction?
Kindly take page 63 of the content. Page 62. That is the part where the commission is directed. Third paragraph, starting with the appellants stroke petitioners. Found to be bona fide working in Ahmadpur, Govindpur.
এক মিনিট এই শুনুন, আমার ওই যে ওই পয়েন্টটা আমার নিজের একটা জাজমেন্ট আছে, ঠিক আছে, আমি তোকে দিয়ে দেবো কন্টেম্পটে, আমি দিয়ে দেবো। আমি 22 নম্বর কোর্টে বসে দিয়েছিলাম ওই 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 মেয়েটি মামলাটা হেরেছিল, কিন্তু খুব ভালো মামলা করেছিল বই ফই দেখিয়ে। যাই হোক, আমি দিয়ে দেবো। Yes.
Found to be a bona fide
The appellant petitioners found to be a bona fide working
in the so-and-so school at the time of its said inspection by the district level inspection team shall be presumed to be the organizing staff and should be recommended by the commission to the board for appointment under section 7 of the act. Here is the difficulty. Because School Service Commission was established to organize recruitment processes for selecting teachers, later on non-teaching staff also. Without a recruitment process, we cannot recommend. So if the court has come to the finding that these appellant petitioners are organizing staff, we have no difficulty because that does not concern us at all. But the method of their appointment and regularization, there lies the difficulty. The statute or the rules does not give me any power to recommend a candidate as an organizer staff, and that too without any recruitment process. So that is now the difficulty where the order, to comply with the order, it has become, I do not want to use the term impossible, but it has become difficult. I am not saying once that it was the state to explain whether they are satisfied with the order of the court that yes, they are to be treated as organizer teachers. If they are to be treated as organizer teachers, then their appointments and their regularization, whatever approvals, are to be given as organizer staff directed by the school respondents, by the school.
Also the second.
By the DI.
The second, no.
That is where the order has gone slightly.
Now you tell us how the problem can be solved and the direction can be complied with.
Firstly, we have filed one review application.
Review?
One review application we have filed.
From this order?
Yes.
No, but it has been upheld by the Honorable Supreme Court.
This matter possible.
This matter. State.
I mean, a petition is the likhane kotha contempt petition je kono SLP kotha. But there is no, I have gone through it, my lord. There is no whisper of any contempt, any SLP in this contempt petition.
Which SLP in contempt?
No. Means in this matter, against this order, any SLP was preferred. No.
I believe this judgment was carried out into SLP. And it was upheld.
But that is not reflected in this petition.
May not be. I tell you why. On the same judgment, on the basis of the same proposition, I delivered my judgment and I allowed the teachers to become regularized in a matter where Mr. Robilal Moitra appeared while I was in 22.
Well, that has been given. Yes. That when this was filed.
Come to page 16 now.
16
document ta
Application adding respondent.
page.
application by Kakoli Dotto for response.
Affidavit in reply, your lordship, can you see?
পেয়ে গেছি দা, পেয়ে গেছি। It is page 16.
Heard by the Honorable Supreme Court on merit and the judgment has been upheld, then the contempt will lie there. Contempt will not lie here.
Oh, Supreme Court has not added a single word.
In the facts and circumstances of the case, we are not inclined to entertain the present petition. The special leave petitions are accordingly dismissed. However, the question of law is kept open.
Question of law.
So the question of
Question of law is kept open, not on this.
Not on this.
The direction is sacrosanct. It has touched.
I am not against the direction.
Tell us how can you implement?
My lord, it cannot be implemented through the hands of the commission.
So
I am not
suggest
Neither from the hands of the board, because direction
suggest
is
the
given.
ways and
Let
means.
the review be listed with this matter. The review is for a very limited point, not on the entire.
How can review is
How
maintainable?
review after the SLP being dismissed?
Let it be listed by your lordship will hold that there was the SLP. But the
No, my lord. It is nothing but delaying the process. Yes. Why not?
I am here with the solution.
No. Whether they have submitted the review application.
Your friends should not try to get the order implemented.
No question of should not try.
Dr. Patro,
No.
Dr. Patro, tell us the solution.
I got two options I can think of. Either allow the review to be listed.
Second option. No. Let how to carry out the direction. Tell us.
For the purpose of carrying out the direction, or else forget about the review. Then this other option is, in a contempt proceeding, it is always open to your lordships to give further directions for the purpose of implementation of the order.
Of course, that we have
Modification
done.
of the order.
Not modification.
Not modification.
Carrying out.
For complete compliance.
Yes.
Absolutely. So you give us the method, the technical method, the procedural method, which you are both of you are master. Tell us the method.
I am the master when there is a recruitment process and it is an organizer teacher. I am no longer the.
No, you both of you come with the
But
suggestion.
let's submit one thing, my lord. Even I want that order of the court, it must be complied with. But difficulty is only one thing. Here, my lord, he has showed his difficulty because he is not, service commission cannot recommend because of this. I mean, the difficulty on my part, your lordship, there is a direction upon the board to issue appointment letter from the date of school, the recognition of the school. So school was recognized back in 2000. So my lord, board became appointing authority in 2018. So my lord, board, when not born as an appointing authority, board cannot issue any appointment letter.
So very well.
And there is two part direction upon the board. One, to issue appointment letter, and second, to regularize. Both are not in the power of board. Neither today board also cannot regularize.
You tell us.
My lord, only that is the reason, my lord, I submitted, my lord, only one, my lord, if your lordship for compliance give a direction of the school authority to issue appointment letter, because your lordship at that prior to 2018, it is the school authority who
School
used
authority has already issued the appointment letter. Now board is to regularize that.
board cannot regularize. It is the
No,
DI
not
who
board. I'm
regularize.
sorry. DI.
If the appointment letter is
Issued that content.
Where are the appointment letters?
There is no
Who is
content.
appearing for the board, state? Who is appearing for the DI? DI is a party in the contest.
Yes, DI is a party.
Who is representing DI?
Mr. Nilotpal said he was here just now.
So you do the needful.
অ্যাপয়েন্টমেন্ট দিয়ে দিচ্ছে স্কুল
আমি বললাম
না সেটা তো কবে দিয়েছে অর্গানাইজার টিচার হিসেবে
So what can be done?
Organizer teacher হিসেবে।
Then when he is saying submitting that school has already given appointment letter.
Where is that? Show us.
This contempt is there is no contempt on part of the board. Why this contempt is taken?
No. That
Show us the appointment letters.
then you also has to take my paper book. It is in the paper.
Paper book is not here.
Yes, yes. তোমাদের দিয়েছিলাম ভাই যখন অরিজিনাল অ্যাপিল করেছিলাম দিয়েছিলাম সবাইকে সার্ভিস করা হয়েছিল
অ্যাপিলে আমি ছিলাম না স্যার।
তুমি ছিলে না তো আমি কি করতে পারি বোর্ড ওয়াজ এ পার্টি তাকে সার্ভিস করা হয়েছিল
কন্টেম্প স্যার আমি
মেবি
Yes.
your lordship kindly see page 43. Page 43, 44, appointment letter.
Yes. Look at it. Show it
Yes,
to
I've
them. Show
seen.
it to them.
This is the appointment letter issued by the school authority
As organized teacher.
as organized teacher
That's right.
1992.
And
So my lord, if the honorable
No,
court
no,
had
no. You
granted-
are requested to join the school
Yes.
as an assistant teacher within 15 days. As an assistant teacher.
So, my lord, any joining of a teacher is an assistant,
Assistant teacher.
And in 1992, my lord, as the school was built, that started functioning that point of time, and he is claiming to be an organizer teacher, it is expected that he has joined the school, got appointment at that point of time. So
yes,
it is.
yes.
It is
And joining letter is also there. Page
So
46.
tell us the solution on the basis.
if my lord, as per my understanding, my lord, now there is a direction of this honorable court to give him an appointment as his appointment
Regularize.
His
regularize.
No, two part. His appointment as an organizer teacher has been approved by the school. So, my lord, his appointment has already been given by the school authority. Second part is the regularization of service. That is upon the DI to do.
DI.
Then, my lord, fresh issuance of appointment letter by the board or recommendation
It's
from
not necessary.
because
Where is Mr. Nilotpal Chatterjee? Send for him. Here is a content matter going on.
আর অরিজিনাল মোহাম্মদ জাস্টিস আইপি মুখার্জির ঘরে আমরা সব কপি সার্ভিস এভিডেন্স সার্ভিস ফাইল করা আছে হ্যাঁ হ্যাঁ অর্ডারের পরেও চেয়েছিলে বোর্ড চেয়েছিল আমরা কপি পাঠিয়েছিলাম কারণ অর্ডারের পরে আমাদের কাছে কপি চেয়েছিল যে পেপার বুক আমাদের নেই হারিয়ে গেছে পেপার বুক দাও কাগজটা নীরোৎপলের জুনিয়র ছিল তো কোথায় গেল জুনিয়রও জানে না কিছু কি করতে জুনিয়রই করে এরা কোর্টের শুধু পয়সা নষ্ট করে গভর্নমেন্টের একটা কথা বলতে পারে না ব্যাপার
Send your clerk outside. What has happened to the junior?
ও গেছে
Where is your clerk?
জার্নির জন্য এই তুই দেখো 35-এ নীলোৎপল আছে
না না এই ছেলেটি যে গেল এখান থেকে ফোন করতে
পেছনে একটা চেয়ার আছে সরি আমি উঠতাম সিস্টার দাদা I said, read an interview.
Already made submission. Already asked the clerk to.
You are briefed in this matter.
জুনিয়র কে আছে
অমৃতলাল চ্যাটার্জি
সে কোথায়
সেও ফোন করছে
বাহ Then you'll also give a very short date so that Mr.
Short date, Mr.
I know, my lord, before the vacation it's not possible. But you'll also see the predicament of the person.
What to do, sir? What do we do, sir?
And after vacation, you'll also visit the circuit.
No, before vacation, that's the difficulty. That's the difficulty. With my regular determination, I'll be carrying out at best next 15 days.
That
7-8 days this month,
that
10
I
days in
know.
September.
That I know. I don't want to disturb your lordship before this vacation, but my predicament is this. 5 minutes if your lordship.
So Aurobindo Chatterjee, Landed Senior Advocate, appears for the
My lord,
petition.
may I give the judgment of our High Court, Honorable Justice Yusuf, said this lordship has clearly held or relying on 2 Supreme Court decisions.
You keep it on that day. First, I will please listen to my order. Ki bollo? MS Mr. Dr. Shutanu Kumar Patro, Learned Counsel, appears for
Number 2.
alleged contender number 2. MS Koeli Bhattacharya, Learned Counsel, appears for alleged contender number 1. Mr. Nilotpal Chatterjee, Learned Counsel, with Mrs. Nilotpal Chatterjee, Learned Counsel, appears for alleged contender number 3. Mr. Shaunak Bhattacharya with Mr. Shaunak Mondol, Learned Counsel, appears for, where are they? Appears for alleged contender number 4 and 5. Relying upon page 44, 43 and 42 and 44. From the paper book filed in FMA 2089 of 2015, MAT 691 of 2015. Mr. Chatterjee and Senior Advocate submits that the school had already issued the appointment letter in favor of the petitioners way back in 1992. He submits that if the alleged contender, if the jurisdictional DI what he will do on this?
He will approve this service. Regularize.
Approves
Biologically,
and approves and regularizes. আচ্ছা কি বললাম? DI directs regularization of the said appointment. Forthwith, the same can be regularized in compliance of the direction of the coordinate bench. Good stuff. Paragraph. In view of the above, Mr. Nilotpal Chatterjee, Learned Counsel, appearing for alleged contender number 3, shall take necessary instruction so that steps can be taken for compliance of the direction of the coordinate bench, wherefrom the contempt arose. Paragraph. It is expected by this court that Mr. Chatterjee shall use his good office for the same. Full stop. Pendency of this proceeding shall not preclude the alleged contender number 3 stroke jurisdictional DI to regularize the appointment of the petitioners
As per the order of this honorable court.
following the direction of the coordinate bench dated
Your lordship can give 1 minute. This is a judgment dated 2nd September 2022.
this September 2, 2022, having been affirmed by the Honorable Supreme Court in its order dated 6 number pada, Supreme Court order.
Your lordship at page 10, yes. Order dated. Supreme Court order
February 27, 2023.
Yes.
Full stop.
February.
27, 2023. কি বললাম?
শান্ত কোথায় গেল? বাইরে কেন দাঁড়িয়ে থাকে? বাইরে দাঁড়িয়ে ঘটনা হচ্ছে ভিতরে বাইরে। ফোনটা ধরো তো।
February 27 তো?
ওই যে ফোন করছে, ফোনটা ধরো।
And to file a compliance report on the next day.
Your lordship is directed to instruction. Mr. Nilotpal Chatterjee will take
instruction and, if possible, to do the needful. The matter shall appear under the heading Contempt Application bracket A assigned on November 19, 2025. Acha, in the paragraph. On the next day, the petitioners shall also file a supplementary affidavit disclosing the appointment letters in this contempt proceeding. Oh, yes.
In this matter, Mr. Mukherjee, I lead by Mukherjee. Lordship, only humble,
19th or 26th.
Lordship, only humble prayer before your Lordship blindly. If Lordship fixed the matter at 2 p.m., so matter can be heard because they
Tell us,
is now 92.
19th or 26th.
19th or 26th. If Lordship 26th at 2 p.m., then it will be.
Sir, I cannot. We
only humble prayer before. Mr. Mukherjee is now 92. That's why
November 26.
Then only one humble prayer, Lordship. He is now 1992. That's why.
My senior
No, no, no,
no,
no, Mr. Mukherjee still. No.
He has also prayed for an accommodation.
I am not on that point. Well, next day I will submit my.
Okay, after Mr. Mukherjee
Yeah,
finishes.
otherwise, my lord, if our senior, well, we take 1 hour or 45 minutes, then it will never be concluded.
That's
Only 2 days, my lord, have done.
চল কি বললাম আসুন
Then Lordship kindly we can take my at 19.
আসুন 19th, all matters are fixed. That's why come on 26th. কি বললাম?
এইগুলো তো 19 তারিখে থাকবে, তুমি নিয়ে কি করবে? পরের সপ্তাহে তো।
বলিনি?
পরের সপ্তাহে তো 26, এগুলো তো
On the prayer of Mr. Shoktinath Mukherjee, learned senior advocate appearing through virtual mode for the petitioner, comma, since he has been suffering from fever, comma, today's hearing stands adjourned, and the matter shall appear under the heading
Review. Application review.
application bracketed review on November 26, 2025. Next. Oh, Mr. Chondi Charan De, learned additional government leaders appears for the state. Thank you. অসুবিধা নেই তো কিছু? অসুবিধা হলে আমি থামিয়ে দেবেন, দিয়ে জিজ্ঞেস করে নেবেন বারবার। ঠিক আছে, নেক্সট।
Get full.
For the review petitioner, on 6th August, my lord was pleased to direct me to serve copy of the learned Advocate General. My lord, I have served the copy.
দেখি কি দেখি? না,
Last order was 6th August. The second page, my lord's order is enclosed.
What is this, sir?
That the copy I have enclosed as passed in the review proceedings, and the letter that I have communicated earlier, as well as the order dated 20.
Where is it? Any affidavit of service?
No, my lord. My lord only directed me to serve the copies.
That's all right.
My lord, if your lordship so desires, my lord, I can file it. My lord, original is with me, my lord.
Mr. Pratik Kumar Bhattacharya, learned advocate appearing for the review applicant.
The original service is there.
Places. I'm keeping it on record.
So, my lord, in the affidavit of service, I shall be annexing the photocopy.
Document. This I'm keeping on record. কি বললাম? A forwarding letter dated August 13, 2025, bearing the seal and signature of the office of the Learned Advocate General for the state, showing receipt of the same by the office of the Learned Advocate General, comma, the original letter is taken on record.
Two photocopies of the same set, my lord, I have submitted.
The said notice was served pursuant to the direction of this court dated August 6, 2025. Paragraph. Even today, unappears for the state. As none had appeared on August 6, 2025 also. Paragraph. In view of the above, the same bunch of document along with the said forwarding letter dated August 13, 2025 shall be served along with a copy of today's order upon Mr. Shishanno Bandyopadhyay, Learned Senior Standing Counsel. And once again at the office of the Learned Advocate General. The petitioner shall file an affidavit of service in this regard on the next day. The matter shall appear under the heading এটা যত্ন করে এখানে রাখুন.
The original be kept with the record. Original.
I have said that. You do one thing. You just take a photograph.
My lord, I have a copy. Also, 2 bunches I have given to my lords.
No, this one.
Yes,
Later.
already photocopy is there with me.
With the receipt.
Yes.
Receipt copy,
Yes,
photocopy
yes.
is there.
Yes.
এটা দরকার
They
নেই
are
রাখার।
from.
এটা দরকার নেই রাখার। ও এটাই তো। এটা ফেরত দিয়ে দিন। Original I am keeping.
So both the copies may I take back, my lord?
No.
This bunch, Xerox copy.
Only that bunch you have given to me.
No, 2 copies I have given for my lords.
Oh. হ্যাঁ একটা ফাইলে থাকছে।
Lordship. So the original be kept with the record.
I have recorded that.
Lordship. Grateful to your lordship.
কি বললাম? Review. কিভাবে আছে? Review within bracket assigned on November 26, 2025.
Grateful to your lordship. My lord, may I pray for one indulgence, my lords? Should I serve copy in the office of the learned GP for the further service upon the learned advocate?
Give it
directly.
Give it to the senior
Mr. Bandyopadhyay directly. Lordship. Grateful to your lordship. With the server copy, my lord, as I lordship.
Time is there, not
Yes,
to
yes.
worry. Server will be done within 2 days, definitely. And time is there.
Grateful to your lordship.
Yes, my lord, I am for the review petition applicant. My lord, today, my lord, I want to file my Supreme Court order and my lord, contempt order. Order of the Supreme Court is, my lord, the sum of the candidates.
You want what today?
Today, I want to file a supplementary affidavit, my lord, of the
On the prayer of Mr.
Manavendra Thakur,
Manavendra Thakur, learned advocate,
along
with Mr. Omlan Jyoti Sengupta, learned advocate, appearing for the petitioner. Leave is granted to the review applicant to file a supplementary affidavit. Upon copy being served on the learned advocate on record for the opposite parties' respondents. Paragraph. Such supplementary affidavit shall be filed on or before September 10, 2025. September 15, 2025.
15.
The matter shall appear under the heading Review assigned on December 3, 2025. Next. Because you will not, it will not, in any way not, matters are all fixed on 19th and 26th. Yes.
This is my application, and a report was called for from the learned registrar general regarding the accounts. This is an application for clarification and modification of the order dated 21st of 21st of December 2021.
Take the microphone, sir.
Well, I'm mentioning before your lordship, hopefully your lordship will not be sitting after this division bench.
No, no. I will take my single bench.
Yeah, I shall be waiting.
Your
But I have a matter in the hearing category as item number 300. I have been waiting. But if nobody is there, of course it will not be. And I do not know whether the next Wednesday your lordship would be sitting.
It will remain in the list.
But there is some urgency, therefore I am here.
Hearing matter, Mr. Banerjee, to be very candid, I
Mr.
do not
Mukherjee.
know whether I will be able to take up before vacation.
So I tell you, lordship, this has come by mistake as hearing matter. Actually, the matter was hard as for orders at the motion stage. And as for orders, it was adjourned. Thereafter, the matter appeared in the list, but it could not be taken up. Now, my lord, I was submitting before your lordship for your consideration that let the matter be placed as for orders, because it will be take hardly 10-15 minutes to 20 minutes, both sides. And in fact,
But before vacation, I don't think, sir.
but if your lordship kindly places it, your lordship will see. If it's not possible, your lordship not.
Because I tell you, sir, September 15 days I will be in circuit.
Yes,
First.
I'm just hearing.
So it will not be possible, sir. Let it remain. Let it remain.
But I do not know after vacation whether the list again changes.
Sir.
Therefore, Lord, I was praying, kindly do not take me amiss. Lord, I am repeating this because of this reason, my Lord. Lord, it's a very simple matter. And your lordship,
Understand. But
and the other side is also there, it will not.
Mr. Banerjee,
Not me, I am
like
Mr.
that, I
am
cannot-
Mr. Mukherjee, not Mr.
I'm so sorry, Mr. Mukherjee. Mukherjee. I'm so sorry. Once again, very sorry.
The difficulty is, I tell your lordship, the difficulty is this, Lord, an order, to be an order which I have said is not an order at all.
No, but
Lord,
Mr. Mukherjee, please.
then,
I
Lord,
will
kindly,
not be able.
Lord, at least, Lord, have a look to it. Kindly keep it as for orders. If your lordship feels, Lord, that is not possible for your lordship because of time constraint,
please,
Lord,
sir.
because it will go to November. In then November, Lord, your lordship sees this difficulty.
Please, before vacation, sir.
Then, Lord, kindly fix it after vacation at the top as
Will
follows.
remain in the list, sir. Please, sir.
And I shall remind your lordship at that stage. Because it's so that your
Let us
lordship
meet
can
after vacation, then we-
after
but-
vacation. I'm very, very sorry to trouble you, lordship.
Sorry, very sorry. Very sorry. Yes.
My lord, I am applicant in this application. In this application, I have made for clarification, modification. The order.
Where is your other side?
My lord, other side is not appearing, and that is the reason your lordship directed for publication of the notice in 3 newspapers. After publication of the notice in 3 newspapers, then your lordship called for a report from the learned registrar general regarding the account. You know, that is the order dated 10th of July 2025. Lordship has passed the order.
দেখুন লিখে নিন চট করে একটা ছোট্ট হ্যাঁ লাস্ট অর্ডারটা কোথায়? 10th July?
10th July. 10th July 2025.
লিখুন ইন রে ক্যান 11 of 2024 বোল্ড করে এই যেরকম আলাদা করে লেখা তার নিচে Mr. Pramod Kumar Drolia with Mr. Santosh Kumar Pandey, learned advocates, appear for the applicant /UOI, Union of India. Pursuant to the direction of this court dated July 10, 2025, the learned registry has submitted a report with regard to the amount deposited with Punjab National Bank. File a status report. File a status report with regard to the amount deposited with the Punjab National Bank. The report is taken on record.
The clarification which I sought for, my lord, the clarification which I sought for in order dated 21st December 2021.
Paragraph none appears for the respondents. Yes.
In order dated 21/12/2021, my lord, as their lordship, as lordship, IP Mukherjee sitting with your lordship, directed that 50% of the amount, which is invested by the learned Registrar General be paid to the respondent and 50% be given to the appellant. Union of India is the appellant. Then, my lord, what happened? The registry raised the issue, my lord, that the interest will be calculated as on the date of the order passed. And secondly, first the amount will be withdrawn by the respondent, then appellant will be paid, and respondent is not coming. Therefore, my lord, this clarification application was filed before lordship, and then none appeared, and the learned advocate who appeared for the respondent, my lord, he took discharge from the matter. Then your lordship directed the notice be served by publication in 3 newspapers, and that publication was made, and affidavit of service was filed before this court, my lord. And then your lordship directed the learned Registrar General to file a account how much amount lying in
That is there.
So therefore, my lord, now on this application, your lordship has to, my lord, that direct, my lord, that the 50% which is the payable to the Union of India being appellant be paid, and the interest be calculated as your lordship directed, as the order made on this 10th July 2025. Account be made up to that date. So up to that date, whatever the amount coming, my lord, the 50% be paid to Union of India, irrespective of the respondent withdrawal. Because the appellant cannot wait for, my lord, the respondent. And this is my only.
You are the respondent.
I am the appellant.
You are the appellant.
I am the appellant, Union of India.
So respondent is not turning out. So you are claiming that money may be released in favor of the appellant.
Appellant 50%.
50%, yes.
Direction of the order dated 21st December 2021.
All right, come on the next day. Give one more notice.
Notice has been given by publication.
Publication.
Yes, my lord. 3 newspapers.
Show us. All right, 1 minute.
Affidavit service.
What is the order dated?
Order dated 21st December 2021, my lord, in my application, page 10. Page 10.
এই দেখি application
Can 11.
ঠিক আছে, তাহলে আপনি চলে যান, কিন্তু এই বাকিটা ওইটা ওনাকে দিয়ে দেন। দাও অ্যাপ্লিকেশনটা দেখি।
Can 11. Kindly have a look at page 10. The order starts, and then, my lord, this is arising out of the land acquisition, my lord. Then, my lord, there was an award, and in award, the arbitrator granted solution interest, and then appeal was filed that under the, my lord, Defense of India Act, my lord, solution interest not permitted. Then, my lord,
Page 10.
page 10, this order start, my lord, in application, my lord, and the relevant part, my lord, that is the operative part, that is, my lord, at page 12, last paragraph. Considering the above facts,
Can
11.
Page is good. Page 10. কোথায় page 10 কিছু নেই। কোথায়?
Look, page 10, the order starts, and page 10 of the application.
Who shall pay the interest now?
Interest, my lord, this is amount has been invested in Punjab National Bank in term deposit.
So whatever has been accrued till today,
Yes.
50% of that shall be paid.
Absolutely, absolutely.
So you are appearing for?
For Union of India appellate.
So Directorate General Defense Estate.
This is the unit of the Union of India.
You are appearing. So you want their 50%. And the rest 50% will remain?
Respondent as and when they withdraw. Prayer A and B of my application.
আসুন দিন। হ্যাঁ সেসব বলছি, তুই শুনে নে। বাকিটা আবার ডিপোজিট করো। কি বললাম? IA CAN 11 of 2024. This application has been taken out by Union of India representing the Defense Estate Officer. Union of India represented through the Defense Estate Officer, Calcutta, Circle. The paragraph, the prayer from the said application, prayers from the said applications are quoted below. Quote 1, page 7, A to C. A to C. First, the respondents being the private individuals are not represented,
Despite service.
despite notice. On the previous occasions also the respondents were not represented. Show me the order for publication and the publication.
Affidavit service. Affidavit service is there. Affidavit of service.
Yes. Pursuant to an order dated March 19, 2025, passed by this court, notice of hearing of this matter with the gist of the content of the application was published in 3 newspapers on June 24, 2025, inviting the respondents to join to be represented in the application, to be represented in the instant proceeding, as would be evident from the affidavit of service affirmed on July 9, 2025, filed on behalf of the applicant. Even the said publication of notice through the newspapers, the respondents are not represented today. Report. Pursuant to the direction paragraph, pursuant to the direction of this court dated July 10, 2025, the section officer within bracket ledger section has submitted a report dated August 19, 2025, the same is taken on record. First, the content of the report is quoted below. এই যে ঠিক আছে, কোড 2। ঠিক আছে, কোড 1টা কোথায়? এই যে কোড 1, বুঝতে পেরেছেন? কোড 2টা পেন্সিল আর কোড 1 এখানে, এই যে পোস্ট। In view of the order, in view of the said order, অর্ডারটা কোড করিনি, এবার অর্ডারটা করব। The relevant portion from the order dated December 21, 2021 is quoted below. Quote 3 from page 12 of the application. পোস্টার, ঠিক আছে। এই যে এখান থেকে পোস্টার, in view of the above, since despite repeated notice, including the notice published in the newspapers, the respondents are not represented, there is no reason to keep the instant application pending. Accordingly, the registry is directed, কোথায় গেল রিপোর্টটা? ক্লারিফিকেশন দরকার কি? তো অর্ডার তো আমার আছে। ঠিক আছে, লাস্ট লাইনে লিখে দেবো, অর্ডার dated such and such accordingly stands modified to be clarified and modified. ঠিক আছে, চলো কি বললাম? Registry is directed to encash the fixed deposits lying with the Punjab National Bank, as would be evident from the report, comma, mentioned above, comma, and then pay 50% of the total accumulation of rupees 1663,671. 16, হ্যাঁ তো দুটোই তো, হ্যাঁ দুটো মিলিয়ে কি বললাম, কিভাবে বললাম? Total 50% কতটা bold of the total accumulation of rupees, bold, 1663,671. To the
Page 13, my lord.
Defense Estate Officer, Calcutta,
Circle. Kolkata Circle.
Calcutta Circle. পড়ুন কি বললাম? One 6,63,671. Duty na kore in favor of the Defense Estate Officer, Calcutta Circle.
Kolkata Circle. My lord. Kolkata Circle.
Kolkata Circle. First paragraph. The balance 50% of the said total accumulation shall again be kept in an interest-bearing fixed deposit amount with the same bank and branch until further direction, and shall remain as such until further direction. Full stop. Paragraph. The Punjab National Bank, the concerned branch of the Punjab National Bank shall take steps and act accordingly in terms of today's order to enable the registry to carry out the direction of this court. Post paragraph. Until further direction. Respondent
Lord, one thing, my lord, that after this, my lord, my withdrawal prayer, my lord, be expedited within 6 weeks from the date of my application.
The entire exercise shall be carried out and completed by the registry, including making payment in favor of the
Defense State Officer.
Defense Estate Officer, Kolkata Circle, positively within a period of 6 weeks from date. 6 weeks from the date of communication of this order. Poster. It is further made clear that paragraph. The balance 50% of the total accumulation, which is directed to be kept in a fixed deposit amount, interest-bearing fixed deposit amount, shall remain as such until further direction of the court. And the original, the registry paragraph is directed to file a report after compliance of today's direction and the report shall be kept in the file of in file. Report and such report shall be kept in the file. Registry shall submit. কি বললাম? To submit. Submit পড়ুন। Submit a report enclosing a copy of the fixed deposit receipts for the balance amount. তারপর বলুন। In the first paragraph. Now, nothing further.
And the application remain pending since the report. But the report will be filed where? The report will be filed.
This disbursement in favor of the Defense Estate Officer, Kolkata Circle, shall amount to full and final satisfaction of all its claim. On the issue.
Good.
All its claim on the issue. কি বললাম? This disbursement and payment. Disbursement কেটে দিন। The payment directed herein. এইভাবে লিখুন। The payment directed herein to be made. The payment directed herein to be made in favor of the Defense Estate Officer, Kolkata Circle, would amount to full and final satisfaction of their claim on the issue. ঠিক আছে? First one. আর কিছু আমার নিশ্চয়ই হবে। হ্যাঁ।
Whether your lordship disposing of this application, because your lordship called for a report, further report.
It will be kept in record, I said. We said. আচ্ছা কি বললাম? And that's for administrative reason, nothing to do with you. আচ্ছা লিখুন, next লিখুন। On the above terms, the order dated December 21, 2021 stands clarified. Stands clarified. Full stop. Paragraph. Accordingly, can 11 of 2024 stands disposed of, comma, without any order as to costs. খুব ধীরে ধীরে ছাপবেন, আস্তে আস্তে ছাপবেন। হ্যাঁ, ওটা থাকবে তো। আপনি সবটা নিয়ে করুন এবং খুব আস্তে আস্তে ছাপবেন। সময় নিন, ক্ষতি নেই আমার একদিন, কিন্তু ভুল যেন না হয়। ঠিক আছে, থ্যাংক ইউ।
জজ সাহেব বসবেন আবার?